You need to move. Right now. I'm not asking twice. He had already decided what she was. That decision cost him everything that came after. He put his hands on a sitting Tennessee state senator on the public steps of Hamilton County Courthouse. He did it in front of a body camera. He did it loudly, in the kind of morning light that leaves nothing in shadow. The 911 dispatch log for that morning would later be read into the record of an internal affairs disciplinary hearing. Incident number CH-2-024-1-0-0441. Date: Tuesday, October 8th. Time of initial call 8:14 a.m. Caller anonymous, reporting a suspicious female, black, approximately 40 to 50 years old, standing near the main entrance of Hamilton County Courthouse, writing in a notebook and photographing posted signage. Call duration 41 seconds. Assigned units: Officer Trent Bullock badge 2214 and Officer Dylan Marsh badge 3087. Simone Graves had arrived at 7:58 a.m. She had stood at the foot of the courthouse steps and done exactly what she had done every morning for 9 consecutive days. She had photographed the laminated notice affixed beside the main entrance, the one that reproduced, in 12-point type, the language of Tennessee Code Annotated Section 10-7-503, which stated that all public records of any governmental entity shall, upon request, be made available for inspection and copying during the regular business hours of said governmental entity. She had noted the time in her folio, 7:59 a.m. Then she had climbed the steps and stood near the top, folio open against her forearm, waiting for the records office to open at 8:30. She was not loitering, she was not trespassing, she was not doing anything that required a police response, but someone had looked out a window and placed a call, and the call had been dispatched. And now Trent Bullock was coming up the steps 2 at a time, one hand rising, shoulder already rotating toward contact, moving with the momentum that belongs to a man who has composed the incident report in his head and just needs the encounter to match what he has already written. You need to move, right now. I'm not asking twice. The words came before he had stopped walking, before he had identified himself, before he had stated a basis for contact, requested identification, or performed any of the procedural steps required by Hamilton County Sheriff's Department General Order 4.12 before initiating a non-emergency stop of a civilian on public property. Simone Graves had read General Order 4.12 in its entirety 7 weeks earlier. She knew exactly what had just been skipped. She did not move. She looked at him the way she had trained herself to look at things that required precise measurement, steadily, without expression, noting what would matter later. Height, 6'2", approximately. Weight, 240. Name tag, Bullock, T. Badge number, 2214. Time on her watch, 8:16 a.m. The second officer, younger, hanging back 2 steps, body camera mounted on his left shoulder, already adjusted a few degrees for a cleaner angle, was watching with the quality of discomfort that means someone already knows this is going wrong. Sir, she said, I'm standing on a public thoroughfare. I haven't been given a reason for this contact. If you have ever watched someone in power mistake stillness for weakness, stay right here. What this officer does in the next 30 seconds will change every calculation he has made for the past 14 years. Bullock closed the distance in 2 steps. His right hand came out and closed around her left forearm. Not a tap, not a guide, a grip. Fingers overlapping, knuckles pressing into the skin above her wrist. He pulled. She came forward off balance, the folio tilting, 3 sheets of notes sliding down to the step below with a sound like a drawn breath. You're going to come with me right now, he said, voice dropping into the register that makes the word arrest audible without being spoken. Or this is going to get a lot worse for you. Dylan Marsh, badge 3087, 22 months on the job, did not step forward. He reached up and adjusted the angle of his body camera by 4 degrees. The gesture was small. It was not accidental. His camera now had a cleaner sightline on the top step. Simone did not pull against the grip. Not immediately. She gave it 2 seconds. the amount of time required for a body camera to capture a clear still of what a hand is doing to a woman's arm, and then stepped back with exactly enough movement to break the contact without escalating it. Officer Bullock. She used his name the way she used timestamps. As a fact, something that would remain when everything else was contested. I'm requesting the legal basis for this contact. I am also requesting that you not touch me unless you are placing me under arrest, in which case I need the stated charge. Bullock's face did something that was not quite surprise. It was closer to recalculation, the expression of a man who has run this kind of encounter many times and is meeting, for the first time, someone who is running a different version of it. He made a decision. Later, reading his incident report, Simone would identify exactly where the decision appeared, not in the language he used, but in what the camera recorded next. He stepped to her left, cutting off the angle to the entrance. His shoulder came between her and the door, and his right hand came up a second time, open, palm flat, and pressed against her sternum and pushed. It was not a punch. It left no immediate mark, but it was contact, initiated without warning, applied with force, against a woman who had done nothing on those steps but stand and ask a procedural question. Simone went back 2 steps and caught the stone railing with her left hand. The folio hit the step. Marsh made a sound. Not a word. Just the involuntary sound a person makes when something crosses a line they did not expect to see crossed. She picked up the folio. She checked the spine, scuffed, and straightened 2 loose pages. She noted the time on her watch. 8:19 a.m. Then she descended the steps slowly, without being rushed, crossed the plaza to the bench at its edge, sat down, opened the folio to a clean page, and began writing. The 9 days before that morning had begun with a drive. Simone had come into Chattanooga the way she always came to places she was studying, from the edges. She took Route 41 south from the airport, past the neighborhoods where the department's use of force records showed the highest concentration of incidents, past the blocks where 9 open complaints against Hamilton County officers had been filed in the past 18 months and processed without resolution, past the corner of Dodson Avenue and Market Street where 4 months earlier a 43-year-old man named Gerald Pruitt had been taken to the ground by 2 officers responding to a noise complaint. Pruitt had not been charged with anything. The complaint against the officers had been classified no merit by Sergeant Doyle Ferris, Hamilton County Sheriff's Department Records Division, without a single witness interview documented anywhere in the file. She knew this because she had read the file. She had read all 9 files. They had been obtained under a Tennessee Public Records Act request submitted 8 weeks earlier, not under her name, not under the Senate's letterhead, but through a law firm that handled legislative research for the Senate Judiciary Subcommittee on Law Enforcement Accountability, which Simone chaired. She had not announced the subcommittee's interest. She had not called the department. She had not sent an aide ahead. She had come herself, alone, in plain clothes, with a worn leather folio and a phone with a good camera, the way she had come to 3 other counties in the previous 14 months. Quietly. Without announcement. To see what a department looked like from the outside when it did not know anyone with authority was watching. The hotel was 2 miles from the courthouse. Mid-range, nothing distinctive. She paid with a personal card and checked in under her own name, which appeared on no sign in Hamilton County, and meant nothing to a front desk clerk who followed local sports and weather, but not Tennessee Senate committee assignments. Each morning she was at the desk by 5:30, coffee from the packet. Folio reviewed against the previous day's notes. Documents reviewed from Aaliyah Vance's encrypted transmissions. Detailed, thorough, sent overnight with the precision of someone who had been working this material for much longer than the past 9 days. Aaliyah Vance was the reason the files had arrived at all. 11 years as a civil rights attorney in Chattanooga. 7 complaints filed against Hamilton County officers. 2 won. 3 settled. 2 still pending. She had also, in the 9 months preceding Simone's arrival, compiled a private evidence file on Officer Trent Bullock that she had shown to exactly one person outside her office. That person was Simone Graves. They did not arrive together or communicate by phone. Their arrangement was not clandestine. It was procedurally appropriate for an active legislative investigation that had not yet been made public, but it was deliberate. If someone at the courthouse tracked the faces that appeared regularly in its corridors, they would not connect the quiet woman with the folio to the attorney whose name appeared on every civil rights complaint filed against the department in 4 years. Day 2 had produced the first real contact. Simone had gone into the records office and requested access to 3 incident reports referenced in Aaliyah's files, but not included in the records release. Documents that were, under TCA Section 10-7-503, public records available on request during regular business hours. The clerk behind the window looked at the request form, looked at her, and slid it back without reading it. Those are under administrative review, not available. Simone picked up the form, noted the time, 2:47 p.m., noted the clerk's name tag, Haley M., noted that no administrative review designation appeared in the public records index she had accessed online that morning, which listed all currently restricted documents and the applicable legal basis for each restriction. "Can I have the administrative review designation in writing?" she asked. "The applicable Tennessee Code section and the estimated date of availability?" Haley M. slid the window shut. Not gently. The frame struck the counter with a sound like a door slamming, a small violence of bureaucracy, the kind that leaves no mark but is clearly intended to end a conversation. Simone stood at the closed window for a moment, looking at the frosted glass, and then wrote, 2:48 p.m. Window closed without response. No documentation provided. She wrote it the way she wrote everything: date, time, action, actor, result. The habit had started in her first term, when a lobbyist made a promise in a hallway and denied it the next morning, and she had learned that memory is not evidence, but a timestamp with context is something considerably more durable. She thanked no one and left. Day 3 had been quieter. She spent it at the courthouse reading room, reviewing public court filings related to 3 civil suits against Hamilton County officers over the past 4 years. 2 had settled with confidentiality clauses. 1 was still active. The active one named Bullock as a secondary defendant. She noted this. She noted the case number, the docket date, the plaintiff's attorney of record, who turned out to be Aaliyah Vance. She noted that the department's motion to dismiss had been denied 7 months earlier, and the case was proceeding to discovery. She also noted that the reading room clerk, a man in his 60s with a lanyard that said courthouse staff, had walked past her table 4 times in 2 hours, not stopping, not speaking, just passing slowly enough that his route would have been inefficient for any purpose other than observation. On his 4th pass, he paused. "You need something?" "No, thank you," she said. "The materials are sufficient." He stood at the edge of her table for a moment longer than the question required. Then he walked away. She noted it. Not an incident, just a pattern. The way a woman alone with a folio and a methodical approach to public documents generates a particular quality of attention in institutions that are not accustomed to being studied. Day 4 had given her Bullock's voice. She was outside the records office, waiting for a supervisor who had been paged at 3:15 and had not appeared by 3:50, when Bullock came through the corridor from the opposite direction. Not hurrying, not on a call, moving through the building with the unhurried proprietary ease of a man who considers the space his. He was talking to another officer she did not yet know, and his voice carried clearly in the marble corridor. He had not lowered it. The corridor was empty except for the woman standing by the records window, and he had assessed her the way people assess furniture, categorized and set aside. "Third complaint this year, filed personally against me," he was saying. "Ferris will close it, same as the other 2. The colleague responded with something Simone couldn't fully hear. Bullock's reply came through clean. "Doesn't matter. Nothing sticks. You know why? Because I document first. Always. Whatever they say I did, I've already got paper in the file saying I did the opposite." He turned into a side corridor. Gone. Simone wrote, 3:52 p.m., Officer Bullock, T, badge 2214. statement regarding preemptive documentation practice, and confidence in complaint dismissal outcomes. No witnesses other than myself. Below it, she underlined 3 words: confidence in dismissal. She returned to the hotel and read all 3 of Bullock's current year complaints in order. First, Jerome Addison, 34, detained 22 minutes outside a convenience store on Dodson Avenue. No arrest, no citation. Complaint: alleged unreasonable detention and excessive force. Classified: no merit within 11 days. Interview log attached to file. 0 witness interviews recorded. Second, Maria Chenoweth, 67, told to get back in her vehicle and stop asking questions during a 40-minute traffic stop for a broken taillight. Complaint against Bullock and 1 unnamed officer. Status: no merit. Interview log: 0. Third, Devin Price, 19, who alleged Bullock grabbed him by the collar and slammed him against the side of a patrol car during what was logged as a field interview. This complaint included a photograph, blurry, taken by a witness across the street, but present. Status: pending at 53 days. No documented action by the assigned investigator. The assigned investigator on Devin Price's complaint was Detective Wes Pruitt. Simone wrote, all 3 complaints processed through Ferris. 0 witness interviews across all 3. Third complaint, with photographic evidence, pending 53 days without a single documented step. Pattern consistent with institutional preemption rather than investigation. She sent 3 words to the encrypted platform: Ferris, Pruitt, Bullock. Aaliyah's response arrived 40 minutes later. Already in the file. Day 6 had produced Ferris in person. She went back to the records office with a formal written request. 2 paragraphs, the correct TCA citation, a specific request for any denial to be documented with an applicable state law basis rather than an internal departmental code. The clerk on duty read it carefully and went to get a supervisor. Ferris came out 12 minutes later, 53 years old, 21 years with the department, the unhurried quality of a man who has determined, over 2 decades, exactly which outcomes are available and which are not, and has organized his life around that determination. He set a printed form on the counter. Records under administrative review are not available for inspection during the review period. This form documents the denial. She picked up the form. The basis cited was Administrative Code 4.7.2, an internal departmental rule, not a state statute, not subject to TCA Section 10-7-503's appeal framework. She did not say so. She thanked him. She left. That evening, she sent Aaliyah a photograph of the form with a note. Internal code, not a state statute. They're using their own rules to override public records law. Aaliyah responded in under an hour. Standard playbook. We've seen it twice before. Documented. We can use it. Day 8 brought rain and the awareness that she was being observed more systematically than she had initially assessed. She arrived at the courthouse at 7:58 as usual. The records office clerk she encountered that morning, not Haley M., not the man from Day 3, but a third person she hadn't seen before, took one look at her request form and said she would need to speak with the supervisor on duty before processing anything. This had not happened on her previous visits. The phrasing was new. She noted it. Ferris appeared from the back office in 4 minutes, faster than usual, as if he had been expecting her. He reviewed the form, told her the records office would not be processing requests from this individual until a supervisory review of previous request patterns was complete, and slid the form back. "What supervisory review?" she asked. "Under what authority?" He did not answer. He turned and walked back into the rear office, the door closed with the soft finality of something that had been practiced. She wrote, October 7th, request denied without stated basis, supervisory review claimed. Ferris D., present within 4 minutes of my arrival. Pattern change. They know I keep coming back. She left. She walked 2 blocks to the coffee shop and sat down and looked at her folio for a while. Then she opened the platform and composed a message to Aaliyah. "They're tightening. I want the sign-in log FOIA. Request filed tomorrow, Not next week. The request went in the following morning, an hour before she climbed the courthouse steps for the 9th time. October 8th, 7:58 a.m. Photographs. Folio. Top step. 8:14 a.m. The anonymous call. 8:16. Bullock coming up the stairs, and then the grip, and then the push, and then the folio on the step, and her hand on the railing, and the time. 8:19 a.m. Noted in the precise, even voice of someone who knows that voice memos and timestamps survive courtrooms in ways that impressions do not. She descended to the plaza bench and wrote, October 8th, 8:21. A.M. Courthouse Plaza. Officer Trent Bullock, badge 2214, made physical contact with my left forearm at 8:16 a.m., duration approximately 4 seconds. Second contact, flat palm to sternum, at 8:19 a.m. No verbal detention order. No stated charge. No lawful basis articulated for either contact. Officer Dylan Marsh, badge 3087, present for both incidents. Body camera mounted on Marsh's left shoulder, active throughout. She closed the folio. Then she went inside to file the complaint. Sergeant Doyle Ferris was at his desk when the front desk called. Bullock had something with a woman outside. She's in here asking to file. He set down his coffee. Room 4, 10 minutes. He was there in 17. Room 4 smelled like carpet adhesive and the particular institutional blankness of spaces designed to receive grievances without transmitting them anywhere. Simone was seated with her folio open and her pen in her hand, waiting with the quality of patience that functions as its own kind of pressure. He set the form on the table and remained standing. Civilian Complaint Form CF-14. Fill it out, return it to the front desk. Standard processing, 30 to 60 days. Thank you. Can you walk me through the witness interview requirement? Interviews are conducted as part of the investigation. Tennessee Post-Counsel Administrative Procedures, Section 9, Paragraph 3, she said, with the evenness of someone reading from a page she has read before, requires that witness interviews be completed before any complaint can be classified as no merit. I ask because the 3 most recent complaints involving Officer Bullock were all classified no merit without a single witness interview documented in any of the 3 files. The room held the particular silence that arrives when something has been said that cannot be called back. Those files are internal. They were released to me under a Public Records Act request 6 weeks ago. She set a printed document on the table, not pushing it toward him, just making it present. It was the official records release letter, department letterhead, date, and case numbers. TCA 10-7-503. I have the full release documentation. He looked at the letter. He looked at her. He took a slow breath through his nose, the breath of a man whose calculations have just been interrupted. Fill out the form, he said. Front desk. He left. He was back in 11 minutes with a new form. That one was outdated. Use this. She looked at both forms. Identical content. The revision date in the lower left corner of the new form was 3 months newer. Thank you, she said. She filled out the new form without comment, noting every field, documenting the submission time, 9:43 a.m., and asked for a written receipt. He told her receipts were not standard procedure. She wrote that in the folio. She told him she would follow up through the Tennessee Post Council's public complaint tracking portal. He said that was her right. He took the form and left without another word. She remained in room 4 for 4 more minutes, reviewing her notes. Then she walked into the corridor and toward the elevator. She took it to the 2nd floor. She walked the corridor slowly, noting the placement of offices, the direction windows faced, the angle of the view down to the plaza below. Ferris's office window faced the plaza directly. She had been visible from that window every morning for 9 days. Captain Delia Corman issued a statement at 10:22 a.m. It went to 3 local outlets and the Chattanooga Times Free Press press list. Subject line, Statement regarding routine. Public interaction. Hamilton County Courthouse, October 8th. 4 sentences. Officers responded to a call about an individual whose behavior had generated concern among courthouse personnel. The interaction was resolved without incident, In accordance with standard procedure, the department was committed to the highest standards of professional conduct. Questions could be directed to public communications. The Word document in which the statement had been drafted carried a file creation timestamp of 9:17 a.m. Simone's complaint had been submitted to Ferris at 9:43. The gap was 26 minutes. The statement had been written before the complaint it was preemptively addressing existed on paper. Simone would not know the precise timestamp until much later, until the document metadata surfaced through a FOIA request Aaliyah had submitted 3 weeks earlier for all communications from Corman's office referencing Bullock's name. But the document existed. The metadata was not editable in any way that did not leave its own trace. And the gap between 9:17 and 9:43 was already a fixed fact in a world that keeps fixed facts indefinitely. She found Aaliyah at noon, at the coffee shop 2 blocks from the courthouse. Back table, wall behind her, door in view. Aaliyah arrived at 12:04, 41, close-cropped hair, the composed bearing of someone who has learned that authority expressed through volume is the least durable kind. She sat down and set her phone on the table without preamble. "They issued the statement before I filed," Simone said. 9:17 save timestamp. I already have it." Aaliyah turned her phone over. On the screen was a screenshot from the department's daily dispatch summary. A public record, on the transparency portal, no request required. The entry for badge 2214, Bullock T, at 8:12 a.m. on October 8th, directed by watch commander to respond to courthouse main entrance, welfare check. Not dispatched in response to a call. Directed. 8:12, Simone said. The 911 call came in at 8:14. They sat with that for a moment. Around them, the coffee shop did what coffee shops do. Steaming milk, background conversation, the ordinary machinery of a Tuesday that did not know it was the Tuesday of something. "Who was watch commander on the 8 a.m. shift?" Simone asked. "Lieutenant Boyd Creech." "I need to meet with him." "Not as a civilian." "No." She set down the water glass. "Not yet." She submitted the Community Concerns Contact Form at 1:15 p.m. Name, S. Graves. Matter, procedural inconsistencies in civilian complaint handling, requesting clarification. The meeting was confirmed for 2 p.m. Lieutenant Boyd Creech was 61, gray at the temples, with the posture that comes from decades of wearing equipment on your belt. His office on the 2nd floor faced the parking structure, which suited his orientation, toward operations, not toward the public face of them. He shook her hand with the professional efficiency of a man for whom this was the 40,000th such handshake, and gestured toward the conference table. She laid it out without raising her voice. The grip at 8:16, the push at 8:19, the statement issued 26 minutes before her complaint existed as a filed document, the dispatch log showing he had directed Bullock to the courthouse 2 minutes before the 911 call that was supposed to have prompted the response. She presented it the way she presented evidence to her subcommittee, chronologically, without accusation, as a sequence of documented facts that led to a conclusion she was not yet naming. Creech listened with the expression of a man who believes the situation is more complicated than the person describing it understands. The expression of someone who has explained institutional complexity for so long that the explanation has become a reflex. Officer Bullock's incident report describes a brief verbal contact with a civilian who appeared to be photographing the courthouse entrance, he said. She declined to provide identification and became agitated when asked to step aside. I did not become agitated. The body camera footage will reflect that. Something passed across his face. A fraction of hesitation, too small to identify with certainty. Footage from this morning is in standard review, he said. Detective Pruitt is handling that review? The hesitation again. The complaint has been assigned to standard investigation channels. Under Sergeant Ferris. Ferris administers the complaint process, yes. Ms. Graves, I want to assure you that every complaint filed with this department, sir, not loud, precise. The interruption of someone who knows that a prepared assurance, once started, is difficult to stop without this kind of intervention. The 3 most recent complaints against Officer Bullock were all closed no merit. The interview logs for each show 0 witness interviews. Post-counsel Section 9 requires those interviews before a no merit classification can be issued. The procedure was not followed in any of the 3 cases. That is not a complicated situation. It is a documented one. Creech was quiet for a moment that lasted longer than most moments in conference rooms. "I'll review the files," he said. "I'd appreciate a written acknowledgement that this meeting occurred and that the review is committed to." He did not agree immediately. She held the ask without filling the silence around it, without softening it, without offering him a route around it. The silence lasted 3 minutes. Then he took a sheet of department letterhead and wrote his name, the date, the time, a sentence. Meeting held with S. Graves regarding complaint filed October 8th. Files to be reviewed, and signed it. She folded it into the folio, thanked him, walked to the elevator. When the doors closed, she wrote, 2:27 p.m., Creech, Boyd, Watch Commander. Written acknowledgement obtained. He knows about the procedural failures. He directed Bullock before the 911 call. He is not lying. He is calculating. Below that, one word, directed. Detective Wes Pruitt reviewed the body camera footage at 3:15 p.m. He was alone in the evidence review room. A narrow space with 2 monitors, a server rack, and a procedure poster whose lamination was peeling at the lower corners in the way things peel when they have been there long enough to stop being read. Pruitt had been with the department for 11 years, 4 of them in investigations. He did not think of himself as someone who did wrong things. He thought of himself as someone who managed outcomes, which is a different self-conception and which had, until today, served him without obvious cost. The footage loaded in 30 seconds. He watched it twice. He noted the timestamp beginning at 8:16:03. The approach, the grip, visible, clear, duration 4.2 seconds. The chest push, fully visible, Bullock's arm extended, the subject's backward step, the folio impacting the step at 8:19:14. He spent several minutes on the section between 8:16 and 8:17. He watched the woman's hands during the grip, completely still, not pulling, not resisting, not giving the footage any ambiguity to work with. He watched her face during the push, equally still, the stillness of someone performing the conscious act of not reacting in the way she might be provoked to react. He recognized that quality. He had seen it before in people who knew exactly what body camera footage was for. He filled out the authentication form, case number, footage timestamp, his own name in the reviewing officer field. In the content summary field he typed, Officer Civilian Verbal Contact, no physical altercation documented. In the authentication status field he selected, Pending Technical Verification, possible timestamp sync issue. He attached the administrative hold flag, which would keep the footage outside the complaint file for up to 30 days under department procedure. He closed the form, set it in the outgoing tray, sat for a moment in the particular stillness of a man who has made a decision and is waiting for it to feel like less of a decision. What Pruitt did not know, because Marsh had told no one yet, was that Marsh had been at a wider angle for the entire encounter, that his camera had captured both physical contacts with greater clarity than Bullock's, and that Marsh had, at 3:40 p.m., copied his footage to a personal encrypted drive that now sat in the glove box of his patrol car. Dylan Marsh was still in his patrol car at 4:20 p.m. He had been sitting there since the end of his shift, engine off, drive in his jacket pocket. He thought about the grip. He had seen Bullock put hands on people before, not often, but enough to know that Bullock was not careless about it, that Bullock understood the line between what a camera would support and what it would not. Today, he had not seemed to be calculating that line at all. He had seemed, for those seconds on the steps, like a man who had forgotten where the line was. He also thought about what she had said after the push. 8:19 a.m. 3 words, quiet, addressed to no one visible. A timestamp spoken aloud to make it real. Dylan had been in law enforcement for 22 months, and in that time he had encountered a great many people, in a great many difficult moments, and he had never heard anyone do that. He had never heard someone document their own assault as it was happening, in a voice that did not shake. He thought about who did things like that. He thought about his father's voice at the academy graduation. Be the officer people need, not the one they fear. At 4:52, he transferred the footage from the encrypted drive to a second encrypted drive. A backup he stored in a fireproof lockbox he kept at home for documents that mattered. He had never used the lockbox for anything before. He still had not decided what to do, but he had made sure there were 2 copies. At 4:55 p.m., the courthouse security sign-in log arrived at Aaliyah's secure server. It had been requested 6 days earlier, through Aaliyah's firm, citing TCA, Section 10-7-503, requesting the Hamilton County Courthouse security sign-in log for all visitors using non-civilian credential designations in the prior 30 days. The courthouse security office had fulfilled it, electronically, at 4:53. Aaliyah forwarded it to the encrypted platform within minutes. Simone opened it in her hotel room at 6:20 p.m. The courthouse security system distinguished between 3 credential categories: civilian, court personnel, and government official. The government official designation used a 2-letter, 4-digit code assigned through the Tennessee Secretary of State's office and issued to sitting state legislators, certain state agency heads, and federal personnel working in official capacity within Tennessee. Simone's code was TN-2847. She had used it at the electronic security kiosk on the ground floor on October 3rd, when she entered the courthouse to review documents in the records office. The kiosk required the designation code for government official access logging, and she had entered it automatically, the way you enter information that has become part of your body's routine. The log showed it now, in a formally released public document, Visitor S. Graves. Date, October 3rd. Time in, 9:12 a.m. Time out, 2:51 p.m. Credential, TN-2847. Designation, government official, Tennessee State Legislature. Anyone who searched TN-2847 in the Secretary of State's public directory would find her name, her district, her committee assignments, and her current role as chair of the Senate Judiciary Subcommittee on Law Enforcement Accountability. She sat with this for a long time. Then, sign-in log has the credential. If anyone in that building pulls it, the cover is gone. Aaliyah's response came at 7:03. Someone already pulled it. Ferris requested a copy of the courthouse sign-in log at 4:38 this afternoon. 4:38. 17 minutes before Simone's own request had been fulfilled. Ferris had gotten there first. She read the message twice, set the phone on the desk, looked at the window. The October evening, Chattanooga moving through its Tuesday without awareness of what was shifting underneath it. Ferris had known what TN-2847 meant, or had found out within minutes of seeing it, because the Secretary of State's directory was public and the search took 40 seconds. And after he knew, he had made a phone call. She could not know its contents yet. She would know later, when the phone records were subpoenaed and the 4-minute, 11-second call at 7:15 p.m. from Ferris's office landline to an unregistered private number became item 17 in a documentary record that neither Ferris nor the person on the other end of that call had been planning to be in. But she knew the call had happened, and she knew what it meant. They were building the wall tonight. 5:30 a.m. on October 9th. She had been at the desk since 5, the folio open beside a legal pad she had filled during the 4 hours she had not slept. She had found the new load-bearing points by 3 a.m. The credential exposure changed the timeline, not the outcome. The outcome had been established by 9 months of evidence, but the timeline compressed now. By morning, Corman would have been briefed. By midday, someone would call someone in the state legislature. By afternoon, the department would be playing offense. She composed 3 messages. To Aaliyah, proceed with the post-council formal notification today. Use the complaint number. I need an official inquiry opened before noon. To her legislative assistant in Nashville, move the subcommittee briefing to Thursday. Confirm all 11 attendees. Do not send formal notice to Hamilton County until I instruct you. To a number she kept for matters that required a different kind of discretion. Need to talk. Not about the county. about what happens when the county realizes they have been talking to the committee chair. She sent all three, made a second coffee she did not drink, opened the folio to a clean page. October 9th, 5:41 a.m. They know the credential. They don't know what we have. Temporary advantage. Use it. At 8:03, Dylan Marsh sat in his car in the department vehicle bay for 11 minutes before going inside. The drive was in his jacket pocket. He had been carrying it since 3:40 the previous afternoon. He was aware of it the way you are aware of something whose weight is not physical. He thought about the footage. He thought about the grip. 4.2 seconds, clear, not ambiguous. He thought about the push. The arm extended, the step back, the folio falling. He thought about the administrative hold flag that Pruitt had placed on the official footage and the notation that said possible timestamp sync issue, and he thought about how that notation was going to look next to footage that showed a clean, uninterrupted time-stamped record with no sync issues of any kind. At 8:14, he went inside. He knocked on Pruitt's door at 9:05, one hand on the frame, not fully in the office, the posture of someone who has committed to arriving but has not yet committed to staying. "The Graves complaint," he said, processing it. "My body camera also captured the incident. I wanted to notify you directly." Pruitt's face did not change. "Log it through the evidence chain." "My angle was wider than Officer Bullock's. The incident is fully captured. I want it on record that I notified you of this at 9:05 a.m. October 9th. Pruitt looked at him for a long moment. 22 months on the job, 24 years old, standing in the doorway with his hands visible and his voice steady, and his footage already backed up twice before he walked into this room. Pruitt understood, in the practiced way of a man who has managed outcomes long enough to recognize when an outcome is managing back, that the situation had become something different overnight. "Noted," he said. "Log it through the chain." Marsh left. Pruitt sat for a moment in the stillness of a man who has used the same play for 11 years and is now watching it not work. Then he picked up his phone and called Ferris. At 9:30 a.m., Bullock came back. Simone was at the plaza bench, not inside the courthouse, but at the bench where she had been sitting the previous morning, this time with both the folio and a legal pad, working through the timeline documentation she had built the night before. She heard him before she saw him, the particular sound of footsteps that announce intention. He came from the parking structure exit across the plaza and approached on a direct line toward her bench. In uniform, not on a call. He arrived and stood over her, arms crossed, using the body the way he used everything, as a statement, as pressure, as the first word in an argument he intended to win by not beginning it. "You're back," he said. She looked up. "This is a public plaza. You filed a complaint yesterday. I exercised my right under the department's complaint procedure. I'm going to need you to come inside and clarify some details. I've provided a written complaint. Any follow-up questions should come through the assigned investigator." He uncrossed his arms. And then, without a word, without a stated basis, without anything that general orders, post-council procedures, state law, or basic constitutional protection supported, he reached down and placed both hands on her shoulders and pulled upward. The motion was abrupt, the kind of physical contact that skips the preliminary of intention and goes directly to outcome. She was sitting, and then she was standing, without choosing to stand, her knee striking the bench arm as she came up, the legal pad falling, the folio sliding from her hands and landing face down on the plaza pavers with the sound of something being ended. She caught her balance. She did not fall. She looked at him steadily, at his hands, which were still on her shoulders, and then at his face when his hands released. "Officer Bullock," she said, her voice carrying across the plaza at a volume designed for body cameras, "you have made physical contact with me without lawful basis for the third time in less than 24 hours. I am documenting this at 9:31 a.m. on October 9th. From the corner of the plaza, from where he had been standing since 9:08 on his personal time, holding a personal device that was not connected to any department system, Dylan Marsh raised his phone, The camera was already recording. Bullock saw it. His hands dropped. He stepped back. He looked at Marsh with an expression that moved through surprise, then anger, then something harder that landed in the register of threat. "Put that away. You're on duty." "I clocked out at 9:05, Marsh said. His voice was steady. The steadiness of someone who has already paid the first part of a cost and is prepared for what comes next. "Personal time. Personal device." The plaza held a moment of the particular silence that arrives when something has irreversibly shifted. 2 tourists 20 feet away had stopped walking. A man ascending the courthouse steps had turned. A woman crossing the plaza with a coffee cup had paused, watching. Bullock looked at all of them. He looked at Marsh. He looked at Simone, who had picked up the folio and the legal pad and was standing, writing, noting the time. He turned and walked back toward the parking structure at a pace that was controlled in the way barely controlled things are controlled, the walk of a man who knows that running would be worse than whatever comes next. Marsh watched him go. You are watching a department that sent a man to silence a problem, and chose, both times, the wrong person to send. Stay with this. The next 12 hours are going to cost every one of them something they cannot recover. Simone found Aaliyah at noon. Same table, same wall. Aaliyah arrived at 12:02, sat down without preamble, and turned her phone over on the table. "Ferris pulled the unit log," she said. "Not the sign-in log, the watch commander's unit directive log. The one that shows Creech directed Bullock at 8:12. He already has it?" "He requested it this morning. The log is a public record and the courthouse released it within 2 hours. Simone looked at the phone. On the screen was the unit directive log entry. Public document, obtained by Aaliyah the previous week through a routine transparency portal request that had been sitting in her files unreviewed until this morning. Directive time, 08:12:04. Directing officer, Watch Commander Creech, B. Reason noted, pre-scheduled welfare contact, courthouse entrance. Pre-scheduled, not reactive, not in response to any call. Scheduled in advance, before any observable event had occurred, before the 911 call existed. "Someone knew I would be on those steps," Simone said. "Or someone had been watching long enough to predict it." Simone looked at her. 9 days of the same routine. Ferris's window, direct sightline to the steps. The shape of it settled. They had not identified her credential before October 8th. What they had identified was her behavior, the consistency of it, the methodical quality of it, the presence of someone who was gathering something. They had not yet known she was a senator. They had known she was a problem. They had sent Bullock to deliver a message. This is what happens to problems that persist. The credential had simply told them how large the problem was. She picked up her phone. She opened the platform and composed, "Send the subcommittee notification to Hamilton County by end of business today. Do not wait for Thursday." Aaliyah read the message over her shoulder. "You sure?" "They know. The difference now is whether we move first or they do." At 2:57 p.m., the subcommittee notification was emailed to Hamilton County Sheriff's Department Public Affairs, the Hamilton County Attorney's Office, and the Tennessee Post-Council Oversight Division. Formally titled, Notice of Legislative Investigative Activity, Senate Judiciary Subcommittee on Law Enforcement Accountability, Chairman Simone R. Graves, Tennessee State Senate District 29. At 3:41 p.m., Simone returned to the hotel. An envelope was waiting at the front desk. Addressed to S. Graves, room 214, no return address. She opened it in the elevator. 2 documents. The first, a civilian complaint form CF-14, filled out under Bullock's name, alleging that S. Graves, civilian, had interfered with an officer in the performance of lawful duties on October 8th and again on October 9th, and had filed a complaint containing materially false statements in potential violation of Tennessee Code, annotated Section 39-16-502, filing a false report. Signed as supervising officer by Sergeant Doyle Ferris. The second, a letter from the department's legal liaison addressed to S. Graves, stating that, given the counter-complaint, the department was initiating a review of the original complaint and requesting that the complainant make herself available for a formal interview with department counsel within 72 hours. The envelope had been delivered by hand. The front desk clerk estimated it had arrived at 2:49 p.m., 8 minutes before the subcommittee notification had been transmitted. They had filed first, by 8 minutes. She read both documents twice, photographed each page with her phone, put them back in the envelope, sat at the desk by the window. Outside, the October afternoon moved through its patterns. Sunlight on the Tennessee River, visible in a narrow slice between two buildings. The ordinary business of a city that did not know it was the Wednesday of something. She called the number in Nashville. "It's me," she said. "They've filed a counter-complaint and requested a compulsory interview in 72 hours. The voice on the other end was quiet for a moment. Then, "They don't know you've already filed with post counsel." "No." "And they don't know about the subcommittee notice." "They do now. It went out at 2:57. A longer pause. "How are they going to respond?" "Tonight," she said. "They're going to try to figure out what we have. Tomorrow morning they're going to start building a narrative. By Thursday, when the subcommittee briefing happens, they're going to want to have already defined what this is." She looked at the folio. "They're not going to get there first." She ended the call. Set the phone on the desk. In the evidence review room on the second floor of the Hamilton County Sheriff's Department, an authentication log with an administrative hold flag and the notation possible timestamp sync issue sat in the outgoing tray. In a fireproof lockbox in a patrol officer's apartment on the east side of Chattanooga, a second copy of 11 minutes and 42 seconds of body camera footage recorded the events of the courthouse steps without ambiguity or technical issue. In the public record, in the Tennessee Secretary of State's directory, in the sign-in log that had been officially released under the Public Records Act, in the dispatch unit directive log that was a transparency portal public document, the name S. Graves appeared beside the credential TN-2847, beside the designation Government Official, Tennessee State Legislature, beside a title that the department's counter-complaint did not know to reference. Senate Judiciary Subcommittee on Law Enforcement Accountability, Chairman. Simone opened the folio to a clean page. October 9th, 3:52 p.m. Counter-complaint filed by Ferris over Bullock's name. Compulsory interview requested, 72-hour window. Notification received 8 minutes after subcommittee notice was transmitted. They filed before they knew about the notice. They're still playing a complaint management game. She paused. Set the pen on the page. Below the last sentence, she wrote 4 words. They lose that game. She capped the pen, closed the folio, looked at the window. The clock that had started running when Ferris pulled the sign-in log was still running. Through this room, through the evidence review room on the second floor, through the fireproof lockbox on the east side of the city, through the servers in Nashville, where the subcommittee's investigative files were now 7 months deep and growing. Through Thursday's briefing, through the post-counsel inquiry that had been formally opened before noon, through the full weight of what Tennessee's legislative oversight structure could bring to bear on a pattern that 9 months of patient, methodical, time-stamped documentation had already proved. Bullock had put his hands on her on the steps of a public courthouse. He had done it in front of a body camera. He had done it in front of a witness who had already made a backup. He had done it to a woman who had been timing the duration of the grip and noting the time of the push in real time, in a folio that was now evidence, in a city where the document that identified her as the chair of the subcommittee with oversight authority over exactly this had been a matter of public record for 9 months. He had done it because he had already decided what she was. Part 2 arrives next, and everything that has been building in the dark, every timestamp and every backup and every document in 9 months of careful work, is about to come fully into the light. The afternoon of Day 5 had introduced Simone to Delia Corman without Corman knowing the introduction was happening. She had been in the corridor outside the second-floor conference rooms, the ones used according to the public calendar for press briefings, when the door opened and Corman stepped out mid-sentence, still talking back over her shoulder to someone inside, voice carrying the smooth control of a woman who has given the same interview 50 times and no longer needs to think about pacing. Corman was mid-40s, impeccably assembled, the kind of assembled that signals not just personal care, but the specific communication that appearance is a tool and she knows exactly how to use it. She turned into the corridor and almost walked into Simone, who was standing 2 feet from the door with her folio, having been reviewing notes while waiting for the water fountain down the hall. "Sorry," Corman said reflexively, and then she assessed Simone in the half-second way people assess strangers in institutional corridors, checking for badge, lanyard, uniform, anything that would categorize, and finding none of those things, her expression moved into the particular form of professional courtesy that institutions direct at members of the public. Polite, bounded, designed to neither engage nor offend. "No problem," Simone said. Corman moved past her. Then, at the end of the corridor, she stopped and turned back. Not because anything about Simone had flagged, more as if something at the edge of her professional attention had snagged without quite resolving. "Are you finding everything okay?" The standard institutional question, directed not at the person but at the category. "Yes, thank you," Simone said. Corman held eye contact for 1 beat longer than the question required. Then she turned and was gone. Simone wrote, Day 5, 3:14 p.m. Captain Delia Corman, PIO, brief corridor encounter. She looked, filed me under civilian, moved on. She is the kind of person who catalogs without being aware she is cataloging. The Day 6 exchange with Ferris had produced something Simone had not expected. After she left the counter with his denial form, the one citing Administrative Code 4.7.2, she had been halfway down the corridor when Ferris appeared behind her. Not hurrying, but not walking his usual measured pace either. He reached her at the corridor junction. "Miss Graves." He said her name with the careful neutrality of someone who has just confirmed it against a form. "These requests you're filing, the pattern of them." She stopped and turned. "Yes?" "Is there something specific you're looking for? Because if you explain what you need, we might be able to direct you to the right materials more efficiently." She looked at him. The offer was reasonable on its surface. It was also, she understood immediately, an invitation to tell him what she knew before she was ready to tell anyone what she knew. "I appreciate that," she said. "I'm looking for what I've requested. The public records release process is the appropriate channel." Ferris held her gaze for a moment. He was not unintelligent. She had understood that from day one. He was a man who had learned how to read situations, which was how he had survived 21 years in a role that required knowing when something was escalating before it arrived. He was reading her now and not quite finishing the read. "Of course," he said. "The process is there for a reason." He went back toward the records office. She watched him go. She wrote, Day 6, 2:58 p.m. Ferris made direct contact in corridor, offered to direct my requests. He is trying to learn the scope of what I have. He does not know yet, but he is beginning to suspect that the pattern of requests is not random. She underlined, not random. Day 7 had been the day she became certain she was being followed inside the courthouse. Not obviously, not the kind of following that would hold up in any formal sense, but she had been in the public reading room for 2 hours when the clerk from Day 3, the one who had walked past her table 4 times, reappeared. This time he set himself up at the reference desk directly in her sightline and remained there, doing things at his desk that looked like work, but involved every few minutes a glance toward her table that held slightly too long. She noted this. She also noted, 40 minutes later, that when she went to the restroom and returned, the copy she had been reviewing, a public court record she had set on the table, had been moved approximately 8 inches to the left. Not knocked over, not removed. Moved, the kind of movement that is either careless proximity or deliberate inspection, followed by imperfect replacement. She photographed the table before sitting back down. She also, when she left the reading room, went not directly to the exit, but to the records window, where she submitted a new request, one she had not been planning to submit that day, for a document she needed less urgently than others in the queue. She submitted it while the clerk was still at the reference desk and could see her doing it. She wanted them to know she was not rattled. She wanted them to know she would keep coming back. Because that was the message that mattered. Not that she had seen them watching, but that the watching had not changed anything she was doing. The hour after the second assault, the 9:31 a.m. shoulder grab on October 9th, had a particular quality that Simone had experienced before in situations where something irreversible has just happened. She sat at the plaza bench. Marsh had remained a short distance away, not approaching, not leaving, standing in the uncomfortable position of someone who has taken a side and is waiting to find out what the side requires. The tourists had dispersed. The man with the briefcase had gone inside. The plaza was ordinary again, the kind of ordinary that reasserts itself within minutes of anything, as if it has been practicing. Simone looked at her knee, which had taken the bench arm during the pull. The fabric of her slacks was not torn. The skin beneath was bruised. She could feel the bruising already, the particular deep ache of contused tissue. But there was no visible mark through the fabric. She noted this. She noted it because a mark that could not be photographed immediately was still a mark, and a mark documented by a physician within 48 hours was evidence of the same quality as a photograph. She would go to a walk-in clinic that afternoon. She would ask for a written assessment. She would provide the exact time and mechanism, bench arm, upward pull, 9:31 a.m., and she would get a signed, dated note that described the contusion with the clinical specificity that made it useful. This was how she had learned to work. Not in the moments of drama, but in the minutes after them, when other people were still processing and she was already building the next layer of documentation. She opened her phone and sent a message to the platform. I need a walk-in clinic recommendation, one with electronic records that can produce a same-day written assessment. And I need Aaliyah to know what happened at 9:31. The response from Aaliyah came in 3 minutes. She had been watching from the car across the street. She had seen both incidents. She had photographed the 9:31 contact from her rear window camera. The photograph was already in the secure file. The clinic recommendation came 4 minutes after that. Hamilton Internal Medicine and Urgent Care on Broad Street. Electronic records. Same-day documentation standard for injury assessment. Simone closed the platform, looked at Marsh, who was still standing at the edge of the plaza. He was watching her with the expression of a man who has used up his certainty and is working from something less structured. She walked toward him. He straightened slightly. Officer Marsh, she said, what you did this morning, the recording, I want you to know I understand what it cost. He was quiet for a moment. I don't know what comes next, he said. It was an honest thing to say, and she heard it as that. You documented what happened, she said. What comes next follows from that. Not from you, from what the documentation shows. He gave a small nod. She walked past him and toward Broad Street. She was at the clinic by 10:15. She was back at the hotel with a signed assessment. Contusion, left knee, lateral aspect, consistent with described mechanism of blunt impact, by 11:40. She photographed it on all 4 sides and uploaded it to the platform with the timestamp and the physician's name and license number. It became Exhibit 3 in the documentary file of the events of October 8th and 9th, before anyone in the Hamilton County Sheriff's Department knew there was a file. The 72-hour interview request in Ferris's countercomplaint had a structural problem that Simone had identified within 2 minutes of reading it. Under Tennessee Code, annotated section 39-16-502, the false report statute the complaint cited, the process for pursuing a complaint of a false report ran through the district attorney's office, not through the law enforcement agency named in the original complaint. The department did not have the authority to compel a subject interview in a matter where it was simultaneously the subject of a formal complaint filed through the post counsel. The interview request was, in its technical construction, an attempt by the respondent in a post-counsel investigation to conduct discovery against the complainant. That was not a procedure that existed anywhere in Tennessee Administrative Code. She had written this analysis out in full on the legal pad, not because she needed to, but because writing it out confirmed that the analysis was correct and would survive being stated aloud in a room with other lawyers. She sent a message to Aaliyah. The counter-complaint's interview request has a procedural defect. The department can't compel this. When do you want to notify them? Aaliyah's response: tomorrow morning. Let them spend tonight thinking they have 72 hours. There was a precision to that answer that Simone appreciated. Aaliyah understood that momentum in these situations was not only about what you had, it was about when you revealed it. Let them build their wall for one more night. Let Ferris make his calls. Let Corman draft her statement. Let Pruitt's administrative hold flag sit in the outgoing tray like a grenade with its pin pulled by someone who did not know it was a grenade. In the morning, Aaliyah would send a single letter, 4 paragraphs, citing the procedural defect and noting that any compelled interview would be challenged under TCA, Section 4-5-301, as an improper adjudicative proceeding. The letter would also note in its second paragraph that the post-counsel inquiry had already been opened, that the formal inquiry notice had been transmitted to the Post-Counsel Oversight Division at 11:53 a.m. that day, and that the department was now a respondent in an active state administrative proceeding. In the 4th paragraph, the letter would note, for the first time in any communication with the department, the full title and name of the person who had filed the original complaint. Senator Simone R. Graves, Chair, Senate Judiciary Subcommittee on Law Enforcement Accountability, Tennessee State Senate, District 29, Hamilton County. That letter would arrive in Ferris's email at 8:07 a.m. on October 10th, 7 minutes before the start of his shift. Simone did not know the exact time the letter would arrive. She knew it would arrive. She knew what it would say. She knew what the department's response would be, the particular quality of institutional silence that precedes a very different kind of noise, because she had been in enough rooms, over enough years, to know what a system sounds like when it realizes it has run out of the kind of maneuvers that usually worked. She sat at the desk by the window and looked at the October evening and wrote the last entry of the day. October 9th, 6:44 p.m. 3 physical contacts documented. Medical assessment complete. POST counsel inquiry open. Subcommittee notified. Counter-complaint procedural defect identified. Marsh footage secured in 2 locations. Aaliyah has the Corman metadata. The sign-in log credential is in a publicly released document. She paused, set the pen down, picked it up. They sent an officer twice, both times in front of cameras, both times documented. They wrote a statement before the complaint existed. They pulled the log before I did. They filed a counter-complaint without checking whether their statutory basis supported the procedure. They are moving fast because they are afraid. Fast and afraid is not the same as effective. She capped the pen, closed the folio, sat in the room that did not look like the center of anything, in the city that did not know what was about to happen inside it. Thursday, the briefing, the 11 attendees, the 9 months of evidence, the medical assessment in Exhibit 3. The footage in a fireproof lockbox on the east side of Chattanooga, held by a 24-year-old officer who had made a decision on a plaza on a Tuesday morning and was still figuring out what the decision meant. The clock was running. Everything else was already done. What Ferris had not known, when he handed Simone the CF-14 form in room 4 and watched her fill it out with the unhurried handwriting of someone taking minutes at an unremarkable meeting, was that the form itself would become evidence. Not its contents. The contents were straightforward, a complaint against an officer, the kind of document that moved through the department system daily with the predictable outcomes that Ferris and Pruitt and the structure they maintained had engineered. What would matter about the form, in the months that followed, was not what was written on it, but what surrounded it in time. The 17 minutes between Ferris's 10-minute promise and his actual arrival, the 11 minutes between his departure and his return with the allegedly outdated version, the 43 minutes of total elapsed time between Simone's entry into room 4 and her submission of the complaint. during which the room's security camera, a fixed dome unit in the upper right corner that the department's own facility records showed had been active and recording since its installation in 2019, had captured the sequence of arrivals and departures and form replacements in their exact order. Simone had noted the camera when she sat down. She had not looked at it directly. She had not made any gesture that indicated she had noted it, but she had adjusted the folio on the table by 3 inches to the right, which put the submission timestamp she was about to write into a slightly cleaner angle relative to the camera's field of view. Small adjustments, made without announcement, the kind of care that looked like no care at all. By the time Pruitt sat in the evidence review room that afternoon watching Bullock's footage for the second time, the full chain of what had happened, from the 812 directive to the 913 contact to the 917 statement saved to the 247 records window to the 438 sign-in log pull, was already assembled in a file on a server in Nashville that Simone had been building for 9 months. The Hamilton County entries were the most recent additions. They were not, by volume, the largest section. They were, by the specificity and contemporaneity of their documentation, among the most precise. Pruitt did not know about the file. He knew about the complaint on his desk. He knew about the footage. He knew about the administrative hold flag he had placed on it and the notation about timestamp sync issues that he had written in the content summary field, and that was, in retrospect, the kind of notation that looks very different in deposition testimony than it does when you are writing it alone in an evidence review room on a Tuesday afternoon in October. He had made the annotation because it was available to him, not because it was true. The timestamps on Bullock's footage had no sync issue. The file's metadata would show that clearly the moment anyone with technical competence reviewed it, which would happen, at the subcommittee's request, through a formal evidence demand, within the week. He had not thought about that. He had thought about 30 days. He had thought about the complaint resolving before it went anywhere. He had not thought about a legislative subcommittee with subpoena authority and a staff attorney who had spent 12 years in evidentiary practice. He would think about it extensively, beginning at 8:15 a.m. on Thursday, when the subcommittee's evidence demand arrived at the department's legal liaison with a cover letter noting the administrative hold flag by its case number and requesting a technical review by an independent examiner within 5 business days. But that was Thursday. On Tuesday afternoon, at 3:15 p.m., Pruitt set the administrative hold flag in the outgoing tray and believed he had handled the situation. Dylan Marsh drove home at 5:30 p.m. on October 9th by a route he did not usually take, longer by 8 minutes, through the neighborhood where Devin Price lived, the 19-year-old whose complaint against Bullock had been pending for 53 days while Detective Pruitt sat on it. He did not stop. He did not know Devin Price's address. He was not even certain why he took that route until he was most of the way through it, and then he understood. He was trying to make it real. The paperwork made it abstract, complaint numbers and case designations and post-counsel procedure references. The neighborhood made it specific. The block made it the kind of thing that had happened to a person in a place, not the kind of thing that happened in files. He drove through it and came out the other side, and went home and took the encrypted drive out of his jacket pocket and set it on the kitchen counter and looked at it for a while. He called his father at 6:45. "Something happened today," he said. His father, retired, 28 years with the Memphis PD, was quiet in the specific way of someone who has received this kind of call before and knows that what is required first is not advice. Marsh told him about the woman on the steps, about the grip he had watched and the push and the folio falling, about the phone he had raised on the plaza that morning, about Pruitt's door and what he had said and the way Pruitt had looked at him when he said it. His father was quiet for a moment when he finished. "The recording," his father said. "The one you made this morning. It's yours?" "Yes." "Is it the only copy?" "No," Marsh said. "I made 2. Another pause. "Good," his father said. "That's good." And then, "The question isn't what you do with it. The question is whether you can look at yourself in 10 years if you do the other thing. Marsh looked at the drive on the kitchen counter. "I know the answer," he said. "I know you do," his father said. "That's why you called me instead of Bullock." At 7:03 p.m., Simone's phone showed a message from the platform. It was from Aaliyah, and it was 3 lines. First line: the Post Council opened the inquiry at 11:53 a.m. The formal case number is PCC-2024-TN-0837. It's in the system. Second line: Corman's document metadata is clean. 9:17 a.m. save timestamp on the statement draft. 9:43 on your complaint submission. 26 minutes. That gap is now logged with the Post Council as Exhibit A-4 in the inquiry file. Third line: I pulled the sign-in log entry for TN-2847 from the Secretary of State's public directory. The cross-reference is confirmed. Anyone who pulled the courthouse log and searched the number has known since 4:38 this afternoon that the person who filed the complaint against Bullock is the chair of the committee that oversees Bullock's department. I don't think they've stopped moving since. Simone read it twice, set the phone down, picked up the pen. She had been building toward this for 9 months across 4 counties. Not toward any single confrontation, but toward the moment when the documentation became too complete to be managed by the mechanisms that departments like this one used to manage documentation. The mechanisms were real, and they were effective, and they had worked, for years, against people who had fewer resources, less time, and less understanding of how to construct an evidentiary record that could survive what was coming. They had not worked against her. And now, at 7:03 p.m. on October 9th, a man in an evidence review room had an administrative hold flag in his outgoing tray. A captain had a press statement with a 9:17 timestamp in the metadata. A sergeant had filed a counter-complaint with a procedural defect he had not caught. And a lieutenant had signed a piece of paper at 2:27 p.m. that put his name, his commitment, and the time he made it into her folio in ink. All of it was going to be read aloud in a room with witnesses. All of it was going to be in a record. All of it was already in a file. She wrote one final entry for the day. October 9th, 7:17 p.m. 9 months of documentation, 2 days of contact, 3 physical incidents on record. POST Council inquiry open at case number PCC-2024-TN-0837. Subcommittee briefing. Thursday, medical assessment in evidence. Marsh footage secured in 2 locations. She paused. Then she wrote the one thing she had not yet written, the thing she had been waiting to write until the structure was solid enough to hold it. They chose the wrong person to make an example of. She capped the pen, closed the folio, placed it in the center of the desk. Outside, Chattanooga settled into its Wednesday evening. The courthouse was dark. The second-floor offices were dark. The plaza bench where she had sat twice in 2 days was empty, the October air moving across the stone surface with the indifference of weather that does not know what has happened near it. In a fireproof lockbox 4 miles away, an encrypted drive held 11 minutes and 42 seconds of footage that Dylan Marsh had decided, at 6:45 p.m., to keep. In an outgoing tray on the second floor of the Hamilton County Sheriff's Department, an authentication form with a false notation sat waiting to become evidence of something its author had not intended it to document. In a server in Nashville, 9 months of patient, methodical, time-stamped work waited for Thursday. The clock was running. The wall they were building overnight would not be ready in time. Nothing in that building was going to be ready in time. Part 2 arrives next. And when it does, every timestamp, every copy, every document in 9 months of careful work comes fully into the open. They sent him twice. He put his hands on her twice, and she documented every second of it. Thursday arrived the way consequential days do, ordinary at its edges, unremarkable in the quality of its light, the temperature, the same cool clarity that had characterized the whole week. Simone was at the desk by 5:15. The folio was full. She started a new one. Same style, same leather cover, same brass clasp, that she had bought at a stationery store near the hotel on day 3, anticipating she would need it. She was on her 3rd coffee when her phone showed the first response. It was not from the department. It was from her legislative assistant in Nashville. Subcommittee confirmed, 11 attendees, all materials distributed, 2 members requesting security clearance for the classification level of the full investigation file. She responded, grant clearance, both of them. Attach the post-counsel case number as reference. Then, at 8:07 a.m., Aaliyah's letter arrived at the Hamilton County Sheriff's Department legal liaison by email. Simone was not there to see how it landed. She did not need to be. She knew its contents precisely. She had reviewed the draft twice before Aaliyah sent it, and she knew, with the kind of certainty that comes from watching the same institutional response pattern across 4 counties, what the next 3 hours would look like inside that building. The letter ran 4 paragraphs. The first paragraph identified Aaliyah's law firm and its representational role. The second cited the procedural defect in the counter-complaints interview request, specifically that TCA Section 39-16-502 directed false report complaints through the district attorney, not through the respondent agency, and that any compelled interview in the context of an active post-counsel investigation would constitute an improper adjudicative proceeding under TCA Section 4-5-301. The third noted that post-counsel inquiry PCC-2024-TN-0837 had been formally opened at 11:53 a.m. on October 9th, that the department was a named respondent, and that the formal inquiry notice had been transmitted to the Post-Counsel Oversight Division that same day. The fourth paragraph read, "Please be advised that the complainant in the above-referenced matter is Senator Simone R. Graves, Chair of the Senate Judiciary Subcommittee on Law Enforcement Accountability, Tennessee State Senate, District 29, Hamilton County. Senator Graves has directed that all future communications regarding this matter be addressed to this office." The subcommittee has initiated a formal legislative investigation into the Hamilton County Sheriff's Department's civilian complaint processing procedures, with particular reference to matters arising from October 8th and 9th, 2024, and the 18-month pattern of use-of-force complaint dispositions documented in the attached preliminary findings. The attachment was 41 pages. At 8:19 a.m., Delia Corman's cell phone rang. She was in her car in the department parking lot, reviewing notes for a 9 a.m. media availability on an unrelated matter, when the call came in from the department's legal liaison. She took it with the professional readiness of someone who fields unexpected calls as part of her daily architecture. She listened for 40 seconds without speaking. Then, "When did this go out?" The answer, 8:07. "And the post-counsel inquiry, since when?" "Yesterday, 11:53. She sat in the car for a moment after the call ended. Outside the windshield, the parking lot was doing what parking lots do in the early morning. Officers arriving, civilian staff, the ordinary institutional metabolism of a shift change. Nobody out there knew yet. In approximately 90 minutes, they would all know something. In approximately 6 hours, depending on how the story moved, the Chattanooga Times Free Press would know something. By evening, Nashville would know something. The question was what story was going to be in circulation by then. She opened her laptop on the passenger seat. The statement she had written Tuesday night, the one time-stamped 9:17 a.m., the one with the 4 careful sentences about routine public interaction and professional conduct standards, was already in the department's draft communications folder. She read it again. Then she closed it without modifying it. There was no version of that statement that was going to help now. What it was, instead, was evidence. And she had the distinct and unpleasant feeling, the specific feeling of a person in public communications who has spent 2 decades managing narratives and is now recognizing that a particular narrative has been managing her, that she had been generating evidence since 9:17 on Tuesday morning. She got out of the car. She had 3 phone calls to make before the 9 a.m. briefing, and none of them were to media. Sergeant Doyle Ferris read Aaliyah's letter at his desk at 8:22 a.m. He read it twice. The second time he read the fourth paragraph 4 times, separately, breaking it into its components. The title, the committee assignment, the county, his county, the district she represented, and the 2 words at the end of the first sentence. She chaired. He had been in law enforcement for 21 years. He had processed hundreds of complaints. He had applied the administrative machinery that the department had built for exactly this purpose: the hold flags, the no-merit classifications, the procedural timelines that absorbed complaints without resolving them, with the methodical competence of someone who had never had reason to question whether the machinery was adequate to every situation it would face. He was questioning it now. He picked up his phone and called Pruitt. Pruitt answered on the second ring. "I saw the email. The hold flag on the footage, it's still in the outgoing tray, it hasn't been processed." "Pull it back." A silence. "Doyle, pull it back. Put the footage back in the active complaint file, and I need you to amend the content summary field. If I amend that field, there's a revision log. It shows the original entry." Ferris looked at the wall above his desk, the procedure poster, the mission statement, the commendation certificates in their frames. "I know," he said. "Pull it back anyway." He ended the call. He sat for a moment in the specific quality of silence that belongs to a man who has just admitted to himself that the machinery is not adequate. Then he picked up the phone again and called the department's union representative. Lieutenant Boyd Creech received Aaliyah's letter at his personal email at 8:31 a.m., courtesy of the department legal liaison's carbon copy distribution. He read it at his desk, standing because he had been standing when it arrived on his phone and had not sat back down. He read the fourth paragraph the way he read things he needed to understand precisely before he responded to them, slowly, without skipping, without filling in the blanks with what he expected to find. He had been watching the pattern of this investigation from the edges. He had seen the records requests escalate in specificity over 9 days. He had signed the acknowledgement letter at 2:27 p.m. on Wednesday at Simone's request, which he had done because declining to sign it would have been worse than signing it, an admission that he was refusing to document a commitment he had verbally made. He had been careful, in every interaction he could recall, to stay on the correct procedural side of the line, without going further than procedure required. He was no longer confident that procedure had been enough. He sat down. He opened the complaint files, all 9 of them, the ones that had been processed in the past 18 months, the ones that had produced 0 witness interviews across everyone. And he read them in order, as if reading them for the first time, which, in a meaningful sense, he was, because this was the first time he had read them knowing who was reading alongside him. At 9:14 a.m. he called the Tennessee Attorney General's office. He did not call the department's legal liaison. He called the AG's public accountability line directly, which was a number he had never called in 26 years on the job, and which he had kept in his contact list for 6 years out of a low-grade institutional caution that had always felt like excessive preparation until this morning. The call lasted 11 minutes. He took 3 pages of notes. When it ended, he sat for a moment and thought about what he had not done and what he had done, and whether the distance between those 2 categories was going to be enough. He did not know the answer. He thought it probably was not, that by the time the subcommittee finished its review of 18 months of complaint files, the fact that he had directed Bullock to the courthouse at 8:12 a.m. on October 8th, 2 minutes before a call that was supposedly the basis for the response, was going to be a question he would answer in a room with a stenographer present. He would answer it honestly. That had been his decision since 8:31, when he read the 4th paragraph of Aaliyah's letter and understood that honest answers were the only ones left. Trent Bullock did not read the letter. He was on patrol. His shift had started at 7, and at 8:07 a.m. he was 3 miles from the courthouse, running a routine traffic check on a vehicle with an expired registration tag on Rossville Boulevard. By the time his phone showed a missed call from the department's union representative, he had already issued the citation and moved on. He called back at 8:52. The union representative, a man named Garrett who handled officer relations for the department's collective bargaining unit, delivered the information in the precise, measured way of someone who has delivered bad news often enough to have developed a syntax for it. "The woman from the courthouse," Garrett said. "She's a state senator." A long silence on the line. "She's the chair of the committee that oversees law enforcement accountability," Garrett continued. "She filed a post-counsel complaint yesterday before noon. There's a legislative investigation, and her attorney's letter is saying the counter-complaint the department filed against her has a procedural defect." The patrol car was parked on Rossville Boulevard. The October morning moved around it. Traffic, a delivery truck, 2 pedestrians with coffee. None of it registered. "The body camera footage," Bullock said. "Pruitt has it flagged." "Pruitt is pulling the flag." A pause. "Trent, I need you to understand something. The situation has changed in a way that the department's standard complaint process cannot contain. You need to retain personal counsel. Today, not through the union, personal private counsel." Another silence. "She's in my county," Bullock said. It was not a defense. It was the sound of a man processing that his geography had become relevant in a way he had not anticipated. "She represents your county," Garrett said. "She chairs the committee that has subpoena authority over your department, and she has been documenting this for 9 months. The traffic moved past on Rossville Boulevard. The delivery truck completed its turn. The pedestrians finished their coffee crossing and disappeared around a corner. 9 months, Bullock said. She had files on this department before she ever stood on those steps. He sat with that for a moment. Then, "What do I do today?" "You finish your shift. You file nothing. You say nothing to anyone in the department about this matter, and you call a private attorney before noon." He called one at 11:38. The attorney, a woman named Carla Fitch, who specialized in officer defense and had a reputation in Chattanooga legal circles for being thorough without being dramatic, listened to the full account without interrupting, asked 4 questions, and said, "Don't speak to anyone in your department about the October 8th or 9th incidents. Don't speak to IA when they contact you, which they will. Don't speak to the subcommittee investigators. Don't speak to media. Speak to me." "Is it bad?" he asked. 3 physical contacts on consecutive days, documented by your own body camera, and a second officer's personal recording, against a sitting legislator who was on public property on both occasions," she said. "Yes, it's bad." The Thursday subcommittee briefing convened in Nashville at 2 p.m. Simone was there in person. She had driven up that morning, 3 hours on I-24, the folio on the passenger seat and the legal pad on top of it. She sat at the head of the table and presented the 9-month investigative file in order: methodology, findings, the Hamilton County complaint pattern, the events of October 8th and 9th, and the documentary record that had been assembled in the 48 hours since. She did not dramatize it. She presented it the way she presented every legislative briefing, chronologically, with citations, with the evidentiary documentation attached as exhibits. The 11 subcommittee members received binders. The binders were indexed. The index ran to 22 entries. Exhibit 1, the 9 use-of-force complaints filed against Hamilton County Sheriff's Department officers in the 18-month period, ending October 7th, 2024, with the post-counsel required interview logs showing 0 witness interviews across all 9. Exhibit 2, the dispatch unit directive log for October 8th, 2024, showing Watch Commander Creech's direction of Bullock to the courthouse at 8:12 a.m., 2 minutes before the 911 call at 8:14. Exhibit 3, the medical assessment from Hamilton Internal Medicine and Urgent Care, dated October 9th, 2024, documenting a contusion of the left knee, lateral aspect, consistent with the described mechanism of blunt impact from a bench arm surface during an upward pull contact. Exhibit 4, the department's public communications statement timestamped 9:17 a.m. on October 8th, 26 minutes before the complaint it addressed was filed at 9:43. Exhibits 5 through 14, the Public Records Act documentation chain, requests, denials, the Administrative Code 4.7.2 citation used in lieu of a state statute, and the Secretary of State's Public Directory entry for TN-2847. Exhibit 15. The Courthouse Security Sign-in Log, officially released, showing the government official credential designation for the October 3rd entry. Exhibit 16. The Department Sign-in Log pull by Ferris on October 8th at 4:38 p.m., confirmed through the Courthouse Records Office's own access log. Exhibit 17. A 4-minute, 11-second call from Ferris's office landline at 7:15 p.m. on October 8th to a number registered to no identifiable individual or business entity, confirmed through the department's public phone billing records submitted under a records request. Exhibit 18. The Post Council Inquiry Case Number PCC-2024-TN-0837, formally opened October 9th at 11:53 a.m. Exhibit 19. The countercomplaint filed by Ferris under Bullock's name, with the procedural defect analysis attached. Exhibit 20. The written acknowledgment signed by Creech at 2:27 p.m. on October 9th. Exhibit 21. The body camera footage from Dylan Marsh's personal device, 11 minutes and 42 seconds, authenticated by Marsh's sworn affidavit, submitted through Aaliyah's firm at 10:14 a.m. on October 10th. Exhibit 22. Devin Price's complaint against Bullock, filed 53 days prior, with the full investigation log showing 0 documented actions by the assigned investigator, Detective Wes Pruitt. The room was quiet in the way rooms get quiet when they are absorbing something large. Senator Marcus Webb, the subcommittee's ranking member, 58, 20 years in the legislature, not known for visible reactions in committee hearings, looked up from Exhibit 21's summary page and said, "When does the post-council investigation produce its preliminary findings?" 90 to 120 days, Simone said. Standard timeline. We can request expedited review given the nature of the physical contacts, which may reduce that to 60. And the AG's office? Creech called the AG's public accountability line at 9:14 this morning. The AG's office has confirmed they received the call and are reviewing for jurisdiction. Webb set the binder down. "This is not a complaint about an officer," he said. "This is a complaint about a system." "Yes," Simone said. "It is." The subcommittee voted unanimously at 3:47 p.m. to authorize a formal legislative investigation into Hamilton County Sheriff's Department complaint processing procedures, to issue a document preservation order to the department effective immediately, and to request, through the Post Council, an independent technical review of the body camera footage authentication chain in the Graves complaint file. Specifically, the administrative hold flag placed by Pruitt and the content summary field amendment logged at 9:41 a.m. on October 10th, when Pruitt had pulled the flag at Ferris's direction. The amendment log existed because Pruitt had been right. When you amend a field in the department's evidence management system, the revision history is automatic and permanent. What had been in the content summary field, officer-civilian verbal contact, no physical altercation documented, was now a line in a revision log that also showed the amended version, officer-civilian contact. Physical contact by officer documented, authentication status, active. The original notation was not gone. It was preserved in the system's audit trail, with the timestamp of its creation and the timestamp of its modification and the user ID of the person who had made each entry. Pruitt's user ID, twice. 8 minutes apart. On the morning after Ferris's phone call, 2 weeks elapsed between the subcommittee authorization and the Internal Affairs disciplinary hearing. They were not quiet weeks. The Chattanooga Times Free Press published the first story on October 14th, sourced to the Legislative Investigation Authorization and the Post-Council Inquiry Case Number, both public records. The headline named Bullock and named Simone, and for the first time in Hamilton County, the public frame of the story was a senator who had been physically assaulted on courthouse steps while conducting a legislative investigation, not a civilian complaint that had been managed and absorbed. Corman issued a statement. It was carefully worded. It acknowledged that a formal complaint had been filed and was being processed through the appropriate channels, that the department took all such complaints seriously, and that it would cooperate fully with any external investigations. The statement was 4 sentences. It contained nothing about what had happened on the steps. It contained no reference to the 9/17 timestamp on her earlier statement. It contained no names. It was, Simone noted when she read it, the best Corpsman could do. And it was not enough. The union issued a separate statement through Garrett expressing confidence in Officer Bullock's professionalism and commitment to public safety, and noting that the department's complaint process was designed to ensure fair and thorough review. This statement was 3 sentences. It also contained nothing that would withstand a question. Marcus Lund, covering the story for the Times Free Press from Day 2, published a second piece on October 18th that included the dispatch log discrepancy, the 812 directive versus the 814 call, which he had obtained through a public records request filed independently on October 10th. He had not found Simone's name through the subcommittee. He had found the sign-in log TN-2847 through the same transparency portal she had used, and from there the Secretary of State's directory, and from there her committee assignment, and from there the public subcommittee authorization vote. He was a careful reporter. He published only what was documented. His third piece, on October 22nd, was about Devin Price. Price had contacted the Times Free Press on October 16th, 2 days after the first story ran. He was 19 years old and had been waiting 53 days for any movement on a complaint that he had filed because an officer grabbed him by the collar and slammed him against a patrol car, and he had a witness and a photograph, and nothing had happened. The third piece ran his account alongside the complaint file documentation, 0 actions by the assigned investigator, the 53-day timeline, Pruitt's name in the investigator field, and alongside 5 other people in Hamilton County who had filed use-of-force complaints in the past 18 months and received no documented response. By the time the IA hearing convened on October 24th, the department's complaint system was not a procedural question. It was a public record. The Internal Affairs disciplinary hearing for Officer Trent Bullock opened at 9 a.m. in a conference room on the 3rd floor of Hamilton County Sheriff's Department. Present, 2 IA investigators from the Tennessee Bureau of Investigation, brought in from Nashville at the request of the AG's office to ensure independence from the department's own IA function, a representative from the Post-Counsel Oversight Division, and the department's legal liaison, who had the distinct quality of a man who had been asked to sit in a room where he was not entirely certain whose interests he was serving. Also present, across the table with Aaliyah Vance to her right and a 3-inch binder in front of her, Simone Graves. Bullock was not in the room. His attorney, Carla Fitch, had submitted a written response to the investigation's preliminary findings on his behalf the previous afternoon. It acknowledged that physical contact had occurred on both dates. It did not acknowledge that the contact was unlawful. It characterized the October 8th events as a good faith response to a legitimate call under circumstances that did not initially make clear the complainant's legislative status. The TBI investigator leading the panel, a woman named Hendricks, mid-40s, with the compact precision of someone who has conducted many hearings and wasted none of them, set Fitch's letter on the table beside the binder. "Senator Graves," she said, "let's begin with the documentation chain. Walk us through it." Simone opened the binder. What followed was 3 hours and 41 minutes of methodical evidentiary presentation, not dramatic, not combative. The rhythm of a record being formally established: claim, exhibit, date, authentication. The grip at 8:16:03, documented by Marsh's footage, Exhibit 21. Duration 4.2 seconds. Contact initiated without stated legal basis. The push at 8:19:14, same footage, Exhibit 21. Awesome. Palm flat, force applied, subject displacement, 2 steps. No stated charge, no Miranda rights issue arising because she was not being arrested, just a woman on courthouse steps who had asked a procedural question. The 9:31 a.m. shoulder grab on October 9th, documented by Marsh's personal recording, Exhibit 21-B, Simone's knee contact with the bench arm. The medical assessment, Exhibit 3. Hendrix's colleague, a man named Ostroff, quieter, who had been making notes throughout, leaned forward. Senator Graves, Officer Bullock's account states that on October 8th, you were photographing the courthouse entrance in a manner that raised concern among courthouse personnel and that he responded to a welfare check directive. The dispatch unit directive log, Simone said, which is Exhibit 2, shows Watch Commander Creech issued that directive at 8:12:04 a.m. The 911 call log, Exhibit 1-A, shows the anonymous call was placed at 8:14. He was directed before the call was placed. A pause. Additionally, she continued, the Tennessee Post-Council General Order for welfare checks requires that an officer identify the basis for contact within 30 seconds of approaching a subject. The footage in Exhibit 21 shows Officer Bullock making physical contact, the forearm grip, within 9 seconds of arrival, without having stated any basis for contact. Ostroff looked at Hendrix. Hendrix looked at the binder. The administrative hold flag, Hendrix said. The one Detective Pruitt placed on the footage authentication. Walk us through that. Pruitt's section of the hearing took 47 minutes and produced 3 moments that were going to be cited in every summary document that came after. The first, the original content summary notation, officer-civilian verbal contact, no physical altercation documented, entered at 3:22 p.m. on October 8th, 11 minutes after Pruitt had watched footage that showed, unambiguously, 2 physical contacts by an officer against a civilian. The second, the revision log entry at 9:41 a.m. on October 10th, where the content summary had been amended to its current version after Ferris's 8:22 call. The revision log was produced from the department's own evidence management system, obtained by the TBI investigators under the Subcommittee's document preservation order. It showed the original entry, the timestamp of the amendment, and Pruitt's user ID beside both. The third, the authentication status field, which Pruitt had originally set to pending technical verification, possible timestamp sync issue, and which the TBI's independent technical reviewer had examined the previous day and found contained no timestamp sync issue of any kind. The footage metadata was clean, continuous, and correctly timestamped throughout. Pruitt was not present in the room. He had, through his own attorney, declined to participate in the IA panel on grounds that the matter was under potential criminal review, and he was asserting his Fifth Amendment right against self-incrimination. The assertion of that right was itself now on the record. Hendrix noted it. She set a printed copy of the technical reviewer's report on the table beside the amended content summary and said nothing for a moment. Then, the possible timestamp sync issue notation. Is there any documentation, any technical report, any communication, any note that supports that characterization as of 3:22 p.m. on October 8th? There was not. Aaliyah had the response ready, the evidence management system's own technical specifications showing that the timestamp sync verification was an automated process completed at the time of footage download and logged separately from the content summary field. The sync verification for Bullock's footage had passed automatically at 12:43 p.m. on October 8th, 2 hours and 39 minutes before Pruitt wrote the word issue. Hendrix made a note. She made it slowly, which was how she made notes that were going to matter. Ferris's portion was shorter than Pruitt's and arrived at its central moment more quickly. The 9:17 a.m. timestamp on Corman's statement draft, the 9:43 complaint submission, the 26-minute gap. Ostroff asked, was the PIO statement drafted based on communication from anyone in this department about the October 8th interaction before the formal complaint was submitted? Ferris's attorney, the department's legal liaison, who had by this point determined whose interests he was serving and it was not primarily the department's, said, I'd recommend my client not respond to that question pending further review. Ostroff wrote something in his notes. The sign-in log pull at 4:38, 2 minutes before the courthouse released Simone's own records request. Ferris had gotten there first. The courthouse access log for the sign-in log system, a document Aaliyah had subpoenaed the previous week, showed Ferris's access request at 16:38. It showed Simone's through the transparency portal at 16:44. 6 minutes apart, not 2. But the order was the same, and the order was what mattered. The 7:15 p.m. call to the unregistered number. Ostroff, Sergeant Ferris, the call at 19:15 hours on October 8th from your office landline. Who were you calling? The department attorney. I understand, Ostroff said. It's noted. He wrote. Then, the counter-complaint filed October 9th under Officer Bullock's signature. Were you aware at the time you filed it that the procedural basis, TCA 39-16-502, directs false report complaints through the district attorney's office rather than through the respondent agency? Ferris said, I filed the form in good faith based on my understanding of department procedures. That's not what I asked. A silence. I believed the procedure was within the department's authority. Were you aware of the post-counsel inquiry that had been opened at 11:53 a.m. that day, more than 7 hours before you filed the countercomplaint? Another silence. I became aware of it, Ferris said, after the countercomplaint was submitted. Ostroff looked at Hendricks. Hendricks looked at the binder. She turned to Exhibit 18, the post-counsel inquiry case number, the transmitted notice, the 11:53 timestamp, and then to the countercomplaint's submission timestamp from the department's own intake log, 18:41, 6:41 p.m., more than 6 hours after the post-counsel inquiry had been formally opened. The document preservation order covered all of Ferris's email traffic from October 8th through the current date. The post-counsel's formal inquiry notice had been transmitted to the department's public affairs email address at 12:09 p.m. on October 9th. That email address was monitored by Corman's office, and its contents were routinely forwarded to relevant department staff. The forwarding log, produced under the preservation order, showed Ferris's name in the distribution at 12:22 p.m., 6 hours and 19 minutes before he filed the counter-complaint. Hendricks said quietly, We'll take a break. The break lasted 14 minutes. When Hendricks and Ostroff returned, Hendricks set a new document on the table. It was a single page, headed Tennessee Bureau of Investigation, Referral Notice, and it bore the date of the current day and the TBI's case number. Senator Graves, she said, the panel is referring the matter of Detective Pruitt's authentication log to the District Attorney's Office for review under TCA Section 39-16-503, tampering with physical evidence. The referral is being made today. She set a second document beside the first. The panel is also referring the matter of Sergeant Ferris's counter-complaint filing, in context of the timeline established by the forwarding log, to the District Attorney's Office for review under TCA Section 39-16-402, official misconduct. She set a third document. With respect to Officer Bullock, the panel's preliminary finding is that the physical contacts on October 8th and 9th were not authorized by any applicable law or departmental procedure, and that the dispatch directive at 8:12 a.m. on October 8th preceded the stated basis for contact. The panel is recommending Officer Bullock be placed on administrative suspension without pay, pending conclusion of the post-counsel investigation and TBI review. The panel is also recommending a formal referral to the Department of Justice Civil Rights Division for potential review under 18 U.S.C. Section 242, deprivation of rights under color of law. A pause. Regarding Watch Commander Creech, the 812 directive is under review. The panel is recommending a formal deposition in Nashville within 30 days. Simone wrote nothing during any of this. She listened. She noted the document numbers. When Hendricks finished, Simone said, "Thank you, that was all." Aaliyah was beside her in the corridor outside the hearing room, and for a moment, neither of them said anything. The corridor was institutional and quiet, and smelled like the same carpet adhesive as room 4 on the second floor below, and the October afternoon came in sideways through a window at the far end. "The DA referrals," Aaliyah said. "They'll take months." "Yes." Bullock's attorney will challenge the suspension. Union grievance. Yes. The DOJ referral may go nowhere. Civil rights cases under 242 are hard. I know. She shifted the folio under her arm. It's a referral, not a conviction. The investigation opens. What happens after that is not something we control. Aaliyah was quiet for a moment. Devin Price's complaint is now 68 days old, Simone said. The document preservation order covers his file. The Post Counsel's independent review will include it. That's not nothing. They walked toward the elevator. The building moved around them with its ordinary institutional rhythms. Footsteps, a phone ringing somewhere, the mechanical sound of the elevator arriving. Simone pressed the button for the first floor. There was a call at 7:15 on Tuesday night, she said. 4 minutes, 11 seconds. Unregistered number. We're never going to know who he called. Aaliyah said nothing. And Corman's statement, Simone continued. The metadata shows 9:17. The filing shows 9:43. But the question of who told her about the incident at 9:17, who gave her enough information to draft 4 sentences before I filed, that question is not in the referrals. It's not in the post-counsel inquiry. It may be in the subcommittee investigation if the document review goes far enough, but it may not. The elevator opened. They stepped in. That's the part that doesn't close, Aaliyah said. Yes. Simone looked at the floor numbers descending. That's how these things go. Dylan Marsh was in the parking lot when she came out. He was not waiting in any official capacity. He was off duty, standing near his car in plain clothes, jeans, a gray jacket, with the look of someone who has arrived at a place without being entirely certain it was the right place to arrive. She saw him from the courthouse exit and walked toward him. He straightened when she approached, the automatic adjustment of posture that some people never quite stop making in the presence of authority. "Senator," he said. The title landed with a small weight, the weight of the word he had not known to apply for 9 days and was now applying for the first time. Dylan. She used his first name with the deliberate naturalness of someone establishing an equal footing. The affidavit, thank you. I just told what I saw. That was the right thing. She looked at him for a moment. How is it? In the department. He was quiet. The parking lot moved around them. A car leaving, a courier on a bicycle passing on the street beyond the barrier. Some people aren't speaking to me, he said. Pruitt, Bullock's unit, a few others. A pause. Some people are. More than I expected. The people who aren't speaking, she said. That changes. It takes time, and it doesn't feel like anything while it's changing, but it does. He looked at her. You've seen this before. Other counties, other departments. She shifted the folio. The officer who does the right thing in these situations doesn't usually become the person everyone admires immediately. They become the person who is tolerated and then respected and then, eventually, the person whose name is mentioned when someone else is trying to figure out what to do. A pause. That's a slower kind of recognition than most people want, but it's the kind that lasts. He was quiet for a moment. My father said something like that, he said. He sounds like someone who earned it. Marsh almost smiled. Not quite, but close. She left him there and walked toward her car. The October afternoon was doing what October afternoons do, cooling at its edges, the light going golden in the way that makes everything look like it is being documented. She put the folio on the passenger seat and the legal pad on top of it, and sat for a moment in the parked car. She thought about what she had not said in the hearing room. The counter-complaint that Ferris had filed, the one citing TCA Section 39-16-502, the one with the procedural defect, had been filed at 6:41 p.m. on October 9th, after Ferris had received the post-counsel inquiry notice and after the subcommittee notification had gone out. It was, in its transparent construction, an attempt to place a piece of paper in a file that would allow someone to say, the senator was under investigation too. Even for one news cycle, even for one day, the counter-narrative might have provided cover. It had not worked because the procedural defect was visible to any attorney within 3 minutes of reading the statute. But it told her something. It told her that the decision had been made quickly, under pressure, by people who were used to having time. She had given them none. That was not accident. The subcommittee notification going out at 2:57, the post-counsel inquiry opening at 11:53, the records requests already filed and fulfilled before the first interaction on those steps. All of it had been designed to ensure that when the wall started going up, the foundation had already been built around it. She started the car. I-24 north to Nashville was 3 hours. She had calls to make on the way. Her legislative assistant, the post-counsel's oversight director, the AG's office contact she had spoken to twice this week. She had a report to submit to the full Judiciary Committee by end of week. She had, on her legal pad, a list of 14 items that represented the procedural work still ahead: the DA referrals to monitor, the document review to supervise, the independent technical review of the footage chain, the deposition scheduling for Creech, the ongoing tracking of Devin Price's complaint in the post-counsel's new review scope. 14 items. None of them quick. None of them certain. Some of them, like the DOJ referral, might produce nothing. Some of them, like Pruitt's tampering referral, might produce charges that a jury declined to confirm. Bullock's suspension would be challenged through the union grievance process, and depending on the panel's composition and the department's appetite for the fight, the challenge might reduce the sanction. The systemic problems, the 9 complaints, the 0 interviews, the machinery of dismissal that Ferris had maintained for years, were documented now, but documentation and reform were not the same thing. The department would announce a procedural review. It would appoint an oversight committee. Whether that committee would have authority, or would meet consistently, or would produce changes that persisted after the media coverage moved on, was a question that no hearing and no subcommittee authorization and no TBI referral could answer. She knew this. She had known it before she drove to Chattanooga for the first time 9 months ago. She had known it in every county before this one. The work was not to produce transformation in a single investigation. The work was to produce a record, documented, authenticated, subpoena-resistant, that made it harder for the next iteration of the machinery to operate invisibly. You did not fix the system in one hearing. You made it visible. You made it accountable. You made it expensive to continue doing what it had been doing, so that the calculation it performed when deciding whether to manage a complaint or investigate it began to include a cost it had not previously had to account for. She pulled onto I-24 north and let the speed settle into something that felt like forward motion. 3 weeks later, at 9:08 a.m. on November 13th, Senator Marcus Webb entered the full Judiciary Committee chamber and called the session to order. The item, the preliminary findings of the Senate Judiciary Subcommittee on Law Enforcement Accountability's investigation into Hamilton County Sheriff's Department civilian complaint procedures, with recommended legislative action. Simone presented for 42 minutes. She did not use notes. The 9 months of documentation had become the kind of knowledge that does not require reference, the kind you carry in the way you carry things that have cost something to learn. The recommended actions were 6. First, an amendment to TCA, Section 38-8-111, the statute governing the post-counsel's complaint review authority, to require mandatory independent investigation by post-counsel investigators, not by the respondent department, for any use-of-force complaint that remained unresolved at 30 days. Tennessee law did not currently require this. It should. Second, a mandatory witness interview requirement, with documentation, before any complaint could be classified as no merit, to be codified in post-counsel administrative rules rather than left to departmental discretion. The discretion had not been exercised. Third, a statewide body camera authentication protocol requiring technical review by an independent examiner before footage could be placed under administrative hold. The Pruitt Amendment was not going to be possible in the same way again if this passed. Fourth, a 30-day response requirement for use-of-force complaints from the date of filing, with automatic escalation to the post-counsel if no documented action occurred within the window. Devin Price's 53 days without a single entry in the investigator's log was now a policy reference. Fifth, the prohibition of counter-complaints filed by the respondent agency against the complainant in any matter where a POST counsel inquiry was already open. The procedural defect in Ferris's counter-complaint had been navigable. The statute should make it unnecessary to navigate. Sixth, a biennial reporting requirement for all Tennessee law enforcement agencies to submit complaint data, filing rate, resolution rate, classification distribution, interview log completion rate, to the Post Council for public posting. The pattern in Hamilton County had not been visible because no one was required to show it. The requirement would make patterns visible. The committee voted 7-2 to advance all 6 to the full Senate for consideration in the January session. The 2 dissenting votes cited concerns about state overreach into local law enforcement operations. Both dissenting senators represented districts with no documented pattern of complaint suppression. Both had received contributions from law enforcement union PACs in the current election cycle. These were matters of public record. They were also, Simone noted in the folio before she left the chamber, not the end of anything. They were the beginning of a vote count she was going to need to build through November and December and into January. On November 14th, the district attorney's office announced it was reviewing the TBI referrals for Pruitt and Ferris. The review would determine whether sufficient evidence existed to present to a grand jury. No timeline was specified beyond the standard language. Review underway. No charges filed at this time. On November 21st, Bullock's union filed a formal grievance challenging the administrative suspension. A hearing was scheduled for January. The union's position, that the IA panel's findings were based on an evidence chain that included footage obtained outside official procedures, Marsh's personal recording, and that the chain of custody did not meet the department's own standards for formal disciplinary action. Carla Fitch, Bullock's personal attorney, filed a parallel motion with the Post Council disputing the preliminary findings' characterization of the October 8th contact as lacking legal basis, arguing that the welfare check directive from Creech, regardless of its timing relative to the 911 call, constituted lawful supervisory authority to initiate a subject approach. The motion was technically sound in a narrow construction. It did not address the 4.2-second grip or the chest push. It addressed only the threshold question of whether Bullock had been lawfully present. He had been. That was the strongest argument available, and it was not going to resolve the footage. Simone read both filings on a Tuesday morning in her Senate office in Nashville, 3 weeks and 2 days after the steps of Hamilton County Courthouse. She read them without surprise. She filed her responses in the folio, date, document title, docket reference, key argument, recommended counter, and set the folio on the credenza behind her desk, beside the 5 other folios that contained the previous 9 months of work, and beside the new one she had started the day after the October 24th hearing. The new folio was for the January session. Devin Price's complaint was resolved, under the Post Council's independent review, on December 3rd. The resolution was not what he had asked for. He had asked for accountability, for something to happen, for someone to confirm that what had been done to him had been wrong. What the Post Council's review produced was a classification change. The complaint was reclassified from pending investigation to sustained with recommendation, meaning that the Post Council had found sufficient evidence of a procedural violation and was recommending that Bullock receive a formal written reprimand for the use of force in the September encounter, and that the department's complaint intake procedures undergo mandatory review. It was not a suspension. It was not a criminal charge. It was a written reprimand and a procedural review recommendation. Devin Price, reached by Marcus Lund for the December 4th story in the Times Free Press, said, "I wanted more than that. I know that's how it works, but I wanted more." He said it without bitterness, with the particular quality of someone who has been disappointed by something he had known, from the beginning, might disappoint him. Lund published the quote in full and beside it published the date Devin Price had filed, the 53 days of no action, and the fact that the October 24th referral had been the mechanism that had moved it at all. The story ran with one other detail. Devon Price was 19. He had filed the complaint himself without a lawyer because he believed the process was there for a reason and he was going to use it. He had been right about the first part. The second part had required 11 more people, 9 months of documentation, and a legislative investigation to achieve what 48 pages of procedural history had not. Simone read the story at her desk at 6:40 a.m. She set the phone down. She thought about the 19-year-old who had taken a photograph and filed a form and waited 53 days and kept waiting because he believed the process was there for a reason. She thought about what it cost to believe that, what it costs to keep believing it when the days accumulate and the investigator's log stays empty, and the form you filed seems to have disappeared into a system that was designed to make things disappear. She opened the folio to the January session's active pages. The vote count was at 5 confirmed. She needed 16 for the full Senate. She had 8 weeks. The January session opened on the 7th. The 6 proposed amendments to TCA Section 38-8-111 and related statutes were scheduled for committee review in Week 2. Simone spent the first week in floor conversations, the particular kind of legislative work that does not appear in records and does not produce quotable statements, the work of explaining what the documentation showed and what the current statute allowed and what the gap between those two things had cost, in one county, over 18 months, to one set of people who had tried to use the process the way it was supposed to be used. She had, by this point, developed an economy of presentation. She did not use the word corrupt. She did not use the word scandal. She used the numbers: 9 complaints, 0 interviews, 53 days, 26 minutes, 8:12 versus 8:14, 9:17 versus 9:43. She let the numbers carry what they had to carry because the numbers were the argument, had always been the argument, and no one was going to dispute them because they came from the department's own records. By Week 2, she had 11 confirmed. By Week 3, 14. The 15th came on a Friday afternoon, in a conversation that lasted 7 minutes in the hallway outside the Senate chamber, and the 16th came the following Monday morning, in a 2-sentence text from a senator who had been undecided for 3 weeks and was now not undecided. The vote was scheduled for the 3rd Thursday in January. It passed 19-14, not unanimous, not close to unanimous, 19-14, with 14 senators who had their reasons, some procedural, some political, some representing constituencies where the law enforcement argument carried more weight than the accountability argument, some representing constituencies where those two arguments were understood to be the same argument, and any choice between them was a false choice. 19-14 was not a transformation. It was a statute. The Tennessee Post-Council Mandatory Independent Investigation Amendment, the Witness Interview Codification, the Authentication Protocol, the 30-day escalation requirement, the counter-complaint prohibition, the biennial public reporting requirement. 6 things in state law that were not there on October 7th. 6 things that would apply to every county in Tennessee, to every complaint filed by every person who picked up a form, because they believed the process was there for a reason. Simone signed the subcommittee's closing summary at her desk at 4:15 p.m. on the day of the vote. The summary ran to 63 pages. It documented the investigation's timeline, its evidentiary basis, its legislative outcome, and its unresolved elements, which occupied 6 pages of the 63, under a section heading that read, Matters Remaining Open. Matters Remaining Open. Pruitt's DA referral, under grand jury review. No charges filed as of closing date. Investigation continuing. Ferris's DA referral, under grand jury review. No charges filed as of closing date. Investigation continuing. Bullock's union grievance, pending hearing, January. Outcome unknown. Bullock's DOJ referral under 18 U.S.C., Section 242, under Civil Rights Division review. No determination as of closing date. Creech's deposition. Conducted, Nashville, December. Contents under AG review. No disciplinary determination as of closing date. The 7:15 p.m. call, October 8th. 4 minutes, 11 seconds. Unregistered number. Recipient not identified. Subject of call not identified. Not resolved. The email marked Situation on steps. Handle before noon. Received by Corman's office. Forwarded internally at 9:04 a.m. on October 8th, 11 minutes before Bullock was directed to the courthouse, 13 minutes before the 911 call. Sender. Address redacted in the department's production of documents. Redaction basis. Sender identification claimed as law enforcement informational source, TCA section 10-7-507 exemption. Exemption contested by subcommittee. Exemption upheld by Hamilton County Chancellor's Court. Appeal filed. Pending. The sender of that email was not known. Might not become known. The exemption was legitimate on its face, and the appeal that Aaliyah had filed, contesting the Chancellor's characterization of the sender designation, was the kind of procedural argument that could resolve in either direction. Simone read the 6 pages twice. Then she signed the summary. She had been doing this work for 14 months across 4 counties. She had produced, in that time, 2 sets of legislative amendments in other states where subcommittee relationships gave her referral capacity. 1 consent decree recommendation that had not been acted on. 1 AG investigation that had produced a civil settlement with no admission of wrongdoing. And now, in Tennessee, in her own district, 6 statutory changes. None of those outcomes was the outcome she would have designed if she were designing outcomes. They were the outcomes that the system produced when it was pressed, consistently and documentably, by someone who understood how to press it and was willing to stay in the room for the pressing. She placed the signed summary in the folio. She labeled the folio, Hamilton County, 2024. She placed it on the credenza in order between the folio labeled Hardin County, 2024, and the space that was going to be occupied, in the coming months, by the folio for wherever she was going next. She called Aaliyah that evening. The vote, Aaliyah said, 19-14. Yes. A pause. The redacted email. Still pending. The appeal could take a year. And whoever sent it is still out there, Simone said. Yes. Another pause. Outside Aaliyah's office, Chattanooga was doing its evening business. A city that had not been transformed, that had not had its corruption excised and replaced with something cleaner, that was proceeding through its January night, the way cities proceed through January nights, with the full weight of its history and the partial, contested, slow-moving fact of 6 new statutory requirements that had not been there before. Devin Price called me this week, Aaliyah said. How is he? He got a job, logistics company, East Side. He said the December 3rd resolution wasn't what he wanted. And then he said, a pause. He said at least they had to put it on paper. At least it's a document somewhere that what happened happened. Simone looked at the credenza, the row of folios. The new one, empty, waiting for its label. That's what it is, she said. A document. Is that enough? It's what we have, Simone said, and it's more than what existed before we started. She ended the call. She set the phone on the desk. In Chattanooga, in the evidence files of the Hamilton County Sheriff's Department, an amended content summary field carried a revision log showing 2 entries, the original, false one, and the corrected one, and the user IDs of the person who had made each. The revision log was not going anywhere. It was part of the record in a case that was part of a post-council inquiry that was part of a legislative investigation that had produced a statute. The statute was now law. The revision log was still evidence. In a fireproof lockbox on the east side of Chattanooga, an encrypted drive held 11 minutes and 42 seconds of footage that Dylan Marsh had decided, in the parking lot of his department at 4:52 p.m. on October 9th, to keep. He was still on the job. He was speaking now to most of his colleagues, and not speaking to a few. The ones he was not speaking to had not filed grievances against him, and had not, in the months since October, given him reason to think they would. He had been commended in the subcommittee's closing summary, a single sentence in a footnote, noting that the independent documentation provided by Officer Marsh was central to the evidentiary foundation of the investigation. He had read the footnote twice, alone, at his kitchen table, and had thought about his father, and had not called anyone. In the Hamilton County Courthouse, the laminated notice beside the main entrance still bore the language of TCA Section 10-7-503. All public records shall be made available upon request during regular business hours. A different person might stand at that entrance someday, in different circumstances, and read it, and believe it, and walk through the door carrying a form. What they would find on the other side of the door was different now than what had been there in October. Not transformed, not fixed. Different in the specific and limited and real way that statutory change makes things different, which is to say, harder to ignore, easier to challenge, more expensive to circumvent. Harder to make invisible. That was the work. That was what 9 months and a folio and a legal pad and a walk-in clinic at 10:15 in the morning and an encrypted drive and a vote of 19-14 produced. It was not everything. It was not nothing. On the credenza in the Senate office in Nashville, a new folio waited for its label. In the department's internal communications archive, sealed pending the appeal of the TCA Section 10-7-507 exemption ruling, one email thread remained with its sender field redacted. Subject line: Situation on steps. Handle before noon. Sent at 8:57 a.m. on October 8th. 13 minutes before the 911 call. The sender was still unidentified. The appeal was still pending. And somewhere in Hamilton County, in an office, in a house, at a desk with a view of something ordinary, someone who had sent that email was reading the news about the 19-14 vote and understanding, perhaps for the first time, that the machinery they had trusted was now running under different rules. That knowledge was not a resolution. It was a different kind of pressure. And the woman who had started the clock, on a courthouse bench, on an October morning, with a folio and a pen and the habit of writing down the time, she was already at her desk, working on the next county. There was one more thing she had not entered into the folio. It had happened on the morning of October 24th, 2 hours before the IA hearing convened, in the courthouse parking lot where she had arrived at 7:30 and sat for a few minutes before going in. A car had pulled into the adjacent space, an older model, unremarkable, and the driver had sat in it for several minutes without getting out. Then the window had come down. Simone had been aware of the car from the moment it arrived, but had not looked at it directly, which was a habit she had developed over years of work that occasionally produced people who wanted to have conversations that did not need to be had. The driver had not said anything. He had looked at her for a moment through the open window and then looked away, at the courthouse entrance, and then back. It was Boyd Creech, out of uniform, off duty. He had looked at her the way a man looks at something he has been thinking about for 2 weeks and has finally arranged himself into proximity to, without being entirely certain what he was going to do once he got there. She had waited. "Senator," he said. Not a greeting, just the word, like a fact being stated. "Lieutenant," she said. Another pause. A car moved through the lot behind them. The October morning was doing its clarity routine, the kind of light that makes everyone look like they are being examined. "I have been in law enforcement for 26 years, Creech said. He was not looking at her now. He was looking at the courthouse entrance. "I have believed, for most of those years, that the problems inside departments get corrected by the departments themselves, that the internal mechanisms work when they need to work." She said nothing. "I am not certain," he continued, "that I have been right about that." He sat for a moment longer. Then he rolled the window up and got out of the car and walked toward the courthouse entrance without looking back. She watched him go. She had not written it in the folio. Some things were not evidence. Some things were just the specific sound that 26 years makes when it realizes it has been wrong about something it cannot return to not knowing. She had held it instead. The way you hold things that are not evidence but are still true. The deposition, conducted in Nashville in December, lasted 4 hours and 17 minutes. Creech answered every question put to him by the AG's investigator. He answered them in the same way he had written the acknowledgement letter at 2:27 p.m. on October 9th, directly, without evasion, in the language of someone who had decided that honesty was what remained available. The transcript ran to 112 pages. The AG's review was ongoing. No determination had been made as of the subcommittee's closing date. The transcript contained, on page 47, the following exchange. Investigator, Lieutenant Creech. On October 8th at 8:12 a.m., you directed Officer Bullock to the courthouse entrance before the 911 call was received at 8:14. What was the basis for that direction? Creech. The basis was an observation that had been relayed to me. Investigator. By whom? Creech. Through the department's internal communications channel. Investigator. Who originated the communication? Creech. It was not identified by name in the channel. It appeared as an administrative notification. Investigator. And you acted on an unidentified administrative notification by directing an officer to approach a civilian? A pause, documented in the transcript as silence, 9 seconds. Creech. Yes. Investigator. Had you seen this type of unidentified notification before? Creech. Yes. Investigator. How often? Another pause. 6 seconds. Creech. More than I should have. The transcript moved on. Page 48. The questions continued. On page 47, in 9 seconds of documented silence, was the edge of something that the investigation had not yet fully mapped. An administrative notification channel through which directions could be issued without identification. A mechanism that produced actions. A welfare check directive, a department dispatch, an officer at a courthouse entrance 2 minutes before a call, without a named source. The redacted email at 8:57 a.m. had not been the beginning of anything. It had been one instance of something that had been running for a while. The subcommittee's closing summary noted this on page 59, in language careful enough not to exceed what the evidence currently supported. Subcommittee investigators are aware of testimony indicating the existence of an internal communications channel through which directives may be issued without source identification. This channel has not been fully mapped as of the closing date. The investigation is being referred to the AG's office for continued review. The referral was pending, the channel was still there, and the woman who had been sitting on a courthouse bench on an October morning, noting the time in a folio with the methodical handwriting of someone who understood that documentation was the only durable answer to power that did not want to be seen. She was already at her desk. Working on the next county. The folio was open. The pen was uncapped. The time, noted in the upper right corner of the first clean page, was 5:42 a.m. It was always 5:42 a.m. somewhere. There was a moment in the 3 weeks between the IA hearing and the full committee vote that did not appear in any document. It had occurred on a Tuesday evening in early November, in the parking lot of a grocery store on the east side of Chattanooga. Simone had stopped there on her way back from a constituent meeting. She was still in Chattanooga regularly, working the legislative calendar from the district office rather than commuting to Nashville every week, because the investigation was still active and being present mattered. She was in the produce section when she became aware, at the edge of her attention, of someone standing still in an aisle where no one was standing still. It was Delia Corman. Corman was holding a bag of apples. She had not seen Simone, or had not yet acknowledged seeing her. The calculation was not clear. She was in civilian clothes, which made her look like someone Simone would not have recognized without context, except that Corman had a quality, even in civilian clothes, of existing slightly apart from her surroundings, as if accustomed to being the person whose presence organized a room. Simone considered continuing past the aisle. She did not. "Ms. Corman," she said. Corman looked up. The expression that moved across her face was complex and fast, something between recognition and the particular quality of a person who has been preparing for a conversation without knowing when it would occur. She set the apples in her basket. "Senator," she said. They stood in the produce aisle of a grocery store on a Tuesday evening in November, and for a moment neither of them said anything. "The statement," Simone said finally. 917. Corman was quiet. "You drafted it before I filed," Simone continued. "Not as an accusation, as a fact, offered in the open air of a produce aisle where there were no cameras and no stenographers and no record of any kind other than the one both of them would carry. Someone told you what had happened before I had the opportunity to file a formal account of it." Corman looked at the basket in her hands, then at Simone. "I was doing my job," she said. And the words were not a defense. They were spoken with the specific quality of someone who understands that the words are true and also that they do not resolve the thing being asked about. "I know," Simone said. "That's the part that stays open." She left the aisle. She completed the rest of her shopping without encountering Corman again and drove back to the district office and did not write what had happened in the folio that evening. Not because it wasn't real, because it was the kind of real that existed between the lines of every document in the case, in the gap between 917 and 943, in the 4 minutes and 11 seconds of the unregistered call, in the 857 email and its redacted sender field, in the space where something was true but not yet proven and might not become proven, in the space where the work continued. Bullock's union grievance hearing concluded on February 3rd. The panel found in favor of the department on the core suspension question. The footage from Marsh's personal recording was admitted over the union's objection, the panel holding that the footage's origin outside official procedures did not affect its evidentiary value in an IA context, but reduced the suspension from indefinite pending post-council resolution to 60 days without pay. 60 days. Not reinstatement. Not termination. 60 days. Carla Fitch issued a statement saying her client believed the contact had been lawful under the circumstances and intended to continue cooperating with the investigation while maintaining that position. The union issued a statement expressing continued confidence in Officer Bullock's service record and noting that the panel's finding represented a significant reduction from the department's original recommendation. 60 days was not what Simone had expected, in the sense that she had not expected any specific outcome. She had learned, over 4 counties and 14 months, to measure outcomes against what was procedurally achievable rather than against what was morally obvious, because the distance between those two measurements was where most of the frustration lived and most of the work happened. 60 days was a suspension. It was documented. It would appear in Bullock's personnel file. It would appear in the next disciplinary proceeding, if there was one, as prior history. It was not nothing. Marsh called her when the finding was announced. She was in the Nashville office, the January session having concluded 3 weeks earlier, the new statutory language now incorporated into TCA section 38-8-111, and sitting in the Tennessee Code annotated, where it would sit until someone amended it, which was both the fragility and the durability of legislative work. 60 days, he said. Yes. A pause. Is that... He stopped. Started again. Is that how it usually goes? Sometimes it's less, she said. Sometimes it's more. It's rarely what you think it should be. What happens after 60 days? He returns to duty. He may face a grand jury if Pruitt's referral produces charges that connect back to him. He may not. The DOJ review could produce something, or it could close without action. She looked at the credenza, the folios. He returns to duty, and he is a different kind of officer now than he was on October 7th, not because anything in him has changed, but because every person in that department knows what is documented, and what is documented follows you. Is that enough? She had been asked that question before. By Aaliyah, about the statute. She had the same answer. It's more than what existed before, she said. Whether it's enough, that's a question the next person who stands on those steps gets to help answer. On March 17th, the Tennessee Bureau of Investigation presented the Pruitt evidence tampering referral to a Hamilton County grand jury. The grand jury deliberated for 2 days. On March 19th, they returned a true bill. Detective Wes Pruitt was indicted on 1 count of tampering with physical evidence under TCA Section 39-16-503. Based on the content summary field notation, officer-civilian verbal contact, no physical altercation documented, entered at 3:22 p.m. on October 8th, after Pruitt had viewed footage showing 2 distinct physical contacts. The indictment also cited the administrative hold flag and its false technical basis. He turned himself in to the Hamilton County Sheriff's Department on March 20th at 9 a.m. He was booked, processed, and released on his own recognizance at 11:41 a.m. He was placed on administrative leave pending trial. The process, arrest to arraignment to pretrial motions to potential trial or plea, would take months, possibly a year. The outcome was not certain. Grand jury indictments were not convictions. Defense attorneys challenged evidence chains. Juries in cases involving law enforcement defendants were historically unpredictable. The conviction rate for TCA Section 39-16-503 in Tennessee over the preceding 5 years was 63%, which meant that in 37% of cases, the documented act of falsifying a record was not sufficient to produce a guilty verdict. Simone noted the indictment in the folio. Date, charge, docket number. She did not note a prediction about the outcome. The folio for Hamilton County 2024 had 22 pages left. She expected to fill them before the case was fully concluded, which might be a year from now or might be longer. The new folio for the next county was already on the desk beside it, open at the first page. The first entry, a date, a location, a series of timestamps. The clock was running again. It always was.